All right, we will call this meeting to order. Welcome to the first meeting of the Joint Judiciary Committee for this interim. Just a few opening remarks. I think everybody here on the committee is familiar with the rules of decorum. The public looking out, seeing all of your bright smiling faces, knowing most of you have attended committee meetings, you're also familiar with the rules. But if you have any questions, I believe there are hard copies by the agenda. Is that right? So if you have any questions, you can consult those rules. Obviously, we want to run an efficient meeting and a respectable meeting, so please keep that in mind as you do testify today. We are set. We have a pretty good agenda. If we stay on task committee, we'll get out early today. And if we stay on task tomorrow, we'll get out even earlier. So just bear that in mind. We've got some flex time, so you can have some fun with these topics or you can be efficient. It's up to you. Or you can be fun and efficient, I suppose. That's an option too. All right, we'll go ahead and call roll.
Mr. Chairman, this is for the Joint Judiciary Committee for May 12th. Senator Crago? Senator Crum? Senator Crum? Senator
Crum
Hicks?
is here.
Senator Hicks?
Excused.
Senator Kolb?
Present.
Representative Brady? Here. Representative Bratton?
Here.
Representative Tustic?
Here.
Representative Filer?
Here.
Representative Kelly?
Here.
Representative Lean?
Here.
Representative Singh?
Here.
Representative Webb?
Here.
Co-Chairman Washit? Chairman Olson?
Here.
You have a quorum, Mr. Chairman.
Excellent. Mr. Co-Chairman, do you have any opening remarks before we get started?
Thank you, Mr. Co-Chairman. Just like to welcome everybody. I think we have some interesting things to discuss over this interim. I really appreciate the work of the LSO in putting together our package for this meeting. A lot of work went into that, and I very much appreciate the staff support. And with that, let's get rolling.
All right. With that committee, we will dive into our first topic, which is strategic lawsuits against public participation. I will note, Mr. Meyer, you are the only person on this topic in person. Everybody else chose to appear by Zoom. So if you choose to leave and appear by Zoom, it won't be unusual. Just okay, very good. All right, with that, we do have a Legislative Service Office memo. Let's go through, let's start with that.
Thank you, Mr. Chairman, Co-Chairman, and members of the committee. I'm Tamara Krola with the Legislative Service Office. We've prepared a topic summary on the topic of strategic lawsuits against public participation, also called SLAPs, and anti-SLAP legislation. We're asked to focus on specifically the topic of the Model or Uniform Act for the consideration of the committee. So I'll just dive into a brief overview of what that model legislation does, how it works, and then I would like to touch on briefly some legislation that has been passed by surrounding states and highlight some differences that they've chosen and how those differences play out in practice. As we've already seen, SLAP stands for Strategic Lawsuits Against Public Participation. SLAPs often come in the form of defamation, invasion of privacy, nuisance, or similar lawsuits sounding in tort. They arise out of many legal arenas, but most likely to arise in issues that are controversial or of great public concern. SLAPs are often involve large corporations or interest groups who use the judicial process to tie up their political opponents in expensive litigation for months or years at a time that are meant to discourage participation. The purpose of anti-SLAP legislation is to prevent or quickly dispose of those types of malicious or frivolous lawsuits. Anti-SLAP laws vary in detail. The legislatures can do a lot of different details, but generally they do four things. Number one, allow for the expeditious dismissal of claims prior to full adjudication on the merits. Number two, they create an automatic stay of pretrial procedures, including discovery and sometimes other pretrial hearings or motions. So in interrogatories, requests for production of documents, subpoenas, all of those are frozen while the court determines the anti-SLAPP motion. The third thing that these laws do is allow for the recovery of costs and attorney's fees incurred by the defendant or the person who's bringing the anti-SLAPP motion. And number four, they allow, excuse me, for the immediate and interlocutory appeal of an order denying an anti-SLAPP motion. Some states have also provided for statutory and punitive damages, or also called exemplary damages, to be awarded to a successful movement. And that's, of course, to deter further actions of similar nature. As of April 2026, 39 states have enacted anti-SLAPP laws. And you can see in the materials that have been provided all of the list of all of those laws and where you can find them. 2 states, Washington and Minnesota, have had their original anti-SLAPP legislation held unconstitutional by their own state Supreme Courts. And I will touch briefly on the reason why those were ruled unconstitutional. So moving into the uniform or the model law, which is called the Uniform Public Expression Protection Act, or the UPEPA. Again, you've been provided the National Conference of Commissioners on Uniform State Laws materials, which go into great detail as to exactly why it was crafted the way it was, and can give you some guidance as to what would be most appropriate in Wyoming if you're considering adopting a similar law. And you can see on the screen right now, we've got a flow chart that was provided in those materials, which is helpful for figuring out exactly what these phases of the anti-SLAPP motion are. So generally, it's considered that they're in 3 phases. The first phase is after a lawsuit is filed, the SLAPP lawsuit, that the defendant or the person who's being sued. And a note about the language there, it gets rather confusing rather quickly, because any party to a lawsuit can actually bring an anti-SLAPP motion. If you are the defendant and you have filed a counterclaim against the plaintiff when you answered, then you could raise potentially a SLAPP counterclaim, which would be then subject to an anti-SLAPP motion filed by the plaintiff. For the ease of trying to understand the flow of the motion, we've just called it the defendant and the plaintiff throughout here. But you'll notice on the spread or on the flow chart behind me that it talks about the movement and the non-movement. The movement is the person who brought the motion. It could be the defendant, it could be the plaintiff. It gets a little confusing. Again, I'll try and keep it as clear as I can. So once filed, the lawsuit, the defendant or the person who's had the claim filed against them has 60 days. And again, these details can be changed. 60 days is the general that I've seen most jurisdictions go with, and that's because they want to keep it towards the beginning of the lawsuit. The part of the point is the expeditious process. So within 60 days, they can file their anti-SLAPP motion. It's a motion to dismiss, to quash, or to strike. In Wyoming, it would likely be a motion to dismiss. The anti-SLAPP motion then creates an automatic stay or freeze of the discovery, as we discussed. And the court will move to, the defendant then has the burden. So the person who filed the anti-SLAPP motion has the burden of proving that the anti-SLAPP statute applies. And the way that you determine whether the anti-SLAPP statute applies is there's a list of categories that the defendant says I was engaging in my protected rights, free speech, petitioning the government, or participating in public activity. And this lawsuit is a direct result of my participation in these protected rights. And once they establish that, then the burden, again, shifts from the defendant to the plaintiff. And the plaintiff has an opportunity to say, oh, but I'm in one of the exceptions to the act. The exceptions to the act include if you're suing the government, if the government is suing you, or if it's just commercial goods. So the first example is, if you're suing government for violating your rights, for defamation or whatever, the government can't turn around and say, no, we have the right to do that. So that's strictly out. The second one is if the government is enforcing a law or something in the benefit of the public. And that's another exception that the anti-SLAPP motion will be denied. The third one is commercial speech broadly is not protected by the government. So if there's an instance where, for example, somebody sues a company for false advertisement and they're trying to sell their goods or services, that company can't turn around and say, I was just doing my free speech. They don't have a free speech right to commercial speech or to false advertisement. So this anti-SLAPP legislation would not apply in that situation. So if the defendant, or sorry, excuse me, if the plaintiff or the non-movement is able to show that one of those exceptions applies, then the anti-SLAPP motion is denied. And the person who brought the motion, the defendant, has a right to immediately appeal that to a higher court. If not, then if they decide not to, then the case will proceed as normal. The discovery stay is lifted. It goes on to the next phase. Excuse me. I'm sorry. I'm trying not to get confused in myself and anybody else. I apologize. The court concludes, if the court concludes the defendant didn't meet its burden, the court denies the anti-SLAPP motion and the defendant can appeal. If the court concludes that the defendant did meet the initial burden, as I said, they can show that there's an exception. If the plaintiff fails to meet that burden, so they can't show that there's an exception, the court proceeds to the second phase of the analysis. So the second phase of the analysis, the court considers whether the plaintiff can make a prima facie case for the lawsuit, the original lawsuit, by establishing an initial showing of every element of the cause of action. So for example, if the lawsuit is for defamation, the plaintiff will need to set forth facts and allegations that, if true, would prove the defendant established statements to a third party, published statements to a third party, that the statements were false, that the statements injured the plaintiff's reputation, and that the plaintiff suffered damages. So if they can set forth facts that survive that prima facie evaluation, the court will then, if they can't do that, the court will then determine that the plaintiff has not met all of its burdens and the anti-SLAPP motion is granted. The case or the cause of action is dismissed, and it's dismissed with prejudice, which means they cannot refile it. The defendant then, the person who brought the motion, the anti-SLAPP motion, is entitled to recover attorney's fees and costs. And this is one of those areas where there's room for unique application. Some states have made it so that the defendant is entitled to recover their costs just for bringing the anti-SLAPP motion. Some have said that they can recover their costs and attorney's fees for everything that they had to do to appear and defend against the lawsuit. So, and sometimes when there's many claims and multiple parties, that can get a lot more complicated and a lot higher costs. If the court determines that the plaintiff has met the burden and has shown that they've got a prima facie case for the original cause of action, we go to the next phase. Next phase of the Uniform Act is that the burden of proof shifts again back to the defendant or the party who filed the anti-SLAPP motion to show that the plaintiff does not have a legally viable case. The defendant can do this by showing that the plaintiff has failed to state a claim upon which relief can be granted, or that there are no genuine issues of material fact and the defendant is entitled to judgment as a matter of law. And I'm sure all the lawyers are familiar with those terms. The first one is the standard for dismissal under the Rules of Civil Procedure 12b-6, and the second is the standard for summary judgment under Rule 56. So presumably the courts would use similar reasoning to evaluate those claims and determine whether the lawsuit should be dismissed under those terms. So the defendant can still succeed even if the plaintiff shows that they've got a prima facie case, if they can show that even if all of the facts that the plaintiff presents are true, then they still don't have a case. They still can't win. So if they're successful, again, the case is dismissed without prejudice. And if the defendant does the defendant meets the burden, the cause of action is dismissed, the defendant is entitled to recover costs and attorney's fees, and the plaintiff can appeal at the conclusion of the case. So again, if that takes care of all of the causes of action that plaintiff has against that defendant, then they can appeal immediately. If not, they have to wait until the rest of the case is concluded to appeal this decision. If the defendant fails to carry the burden, the anti-SLAPP motion is denied, and the defendant is entitled to immediate interlocutory appeal of that decision. So the defendant or the person who made the anti-SLAPP motion does not have to wait until the case is finally adjudicated. They can go ahead and appeal immediately. Under the UPIPA, the attorney's fees, costs, and expenses related to filing the anti-SLAPP motion must be awarded to the defendant if the motion is granted. On the other hand, the plaintiff is only entitled to recover attorney's fees, costs, and expenses if the court finds that the motion was frivolous or filed solely with the intent to delay the proceedings. My review of the state laws that we've looked at for the purposes of this topic summary found that's pretty uniform, that kind of slightly unequal in the terms of who gets attorney's fees, but it seems to be pretty well established that that's how everybody's done it. All right, and I guess I can stop there for a second, and if you have any questions about this UPIPA process in particular.
Representative Chestick, go ahead.
Thank you, Mr. Chairman, and thank you for the summary, excellent summary. I'm just a little confused about the phase 3 because as I understand it, when a motion is filed, discovery, it is filed very early in the case before any discovery really has started, and the discovery is stopped. But then in phase 3, we have the summary judgment standard, which usually happens after discovery has occurred. And, you go to the court and say, well, with all this discovery, we can now say there is no genuine issue material fact. How can you make that showing that early in the case before any discovery has happened?
Thank you, Mr. Chairman. Representative Chestick, that's an excellent question. And in fact, some of the courts have struggled with that very question themselves. There is a problem, and in Wyoming, we do have case law that's well established that summary judgment is often inappropriate before discovery is completed. And the way that the commissioners have talked about it in the model materials is they make it clear that even though it may seem like what they're asking the court to do is to weigh the evidence, they're not, in fact, doing that. Some states have also allowed for the parties to request additional discovery, or if it's just discovery related to the anti-SLAPP motion itself, and the court has discretion to allow limited discovery, which somewhat gets around it. But I do think that is something of concern that a lot of courts have struggled with in determining whether it's appropriate to actually rule on summary judgment or that summary judgment standard of no genuine issues without giving the parties an opportunity to fully flush out the facts in discovery. So, and a lot of times, I think that we've seen attempts by other state legislatures to add language that, defines whether they should be reasonably likely to succeed. And that's even run into more trouble, which I'll talk about a little bit more on some of these other cases. But I think that's something that the legislatures have struggled with, and the courts more have tried to find the balance how are we going to do this? So I think that there are some guidance that you can see in here that would help courts if you can word it in such a way that you're directing the courts to either allow some limited discovery on this issue if there's anything specific, or to, maybe at that point, it would just have to be a denial of the anti-SLAPP motion, because if they don't have the facts yet, then they can't meet that burden of summary judgment. I hope that answers the question.
Senator Cole.
Yeah, thank you, Mr. Chairman. So I'm going to try to phrase this because I'm not an attorney, so pardon me if I don't get it quite right. But the issue about equity in fees between both parties, why does it slightly favor one party over the other? And if that's the case, what is the justification? How could that, I guess as a person who always looks at balance, how could it be correct to favor one party over the other instead of treating them equally? So is there an explanation on, I guess, what other states have done and why they've done it? Has it stood up to the test of the courts? Thank you, Mr. Chairman.
Tamara?
Thank you, Mr. Chairman. Senator Kolb, that's another excellent question. I think that the difference lies in the issues of what behavior is being deterred or prevented versus also a determination of whether the lawsuit itself is frivolous versus whether the anti-SLAPP motion was frivolous. I think that the balance shifting or the cost shifting is played out in the fact that, well, let me back up just a little bit. Some states have made it mandatory that the person who brings an anti-SLAPP motion who is successful is entitled to, must be granted attorney's fees and costs. And some states have left it more discretionary. That is always an option to allow the court discretion to determine whether the facts of each specific case justify an award of attorney's fees or costs, depending on how egregious the lawsuit was. If it's all on its face, there was no cause of action here, then the court can say, well, that was frivolous and we're going to award attorney's fees. Or they could say, we think that it doesn't justify attorney's fees in this instance. So that is, it really is a matter of what the legislatures have determined, what kind of behavior, what kind of lawsuits they want to deter or prevent. And so that the cost of attorney's fees is an added deterrence in those cases. Does that answer your question?
Senator Kolb?
Yeah, thank you, Mr. Chairman. Well, not really.
I'm sorry.
In a scenario where, I'll just put it this way, you have a person filing an anti-SLAPP lawsuit who's frivolous. And then the other party has to then represent themselves and defend themselves against that SLAPP lawsuit that indeed was frivolous. Why wouldn't the other party be, and maybe I'm not reading this right, wouldn't be entitled to all legal fees associated with defending themselves against a frivolous anti-SLAPP lawsuit? That's really my question. Or is that already envisioned in this bill draft or your information? Thank you, Mr. Chairman.
Tamara?
Thank you, Mr. Chairman. Senator Kolb, that I think that there's a little confusion. It just does get so confusing when we talk about the different motions and lawsuits. The anti-SLAPP is a motion that is filed inside of another lawsuit. It's not a separate lawsuit. So when somebody files a defamation case, for example, that's the SLAPP lawsuit. That's the one that's frivolous. And so then the anti-SLAPP motion is filed by the defendant who says, this is a frivolous lawsuit. I shouldn't have to pay for this. And that is why the most of the laws allow that once the defendant files that motion and says, this is a SLAPP lawsuit and it's frivolous and here's why. And then the court says, yes, it's a frivolous lawsuit. We're going to dismiss it. Then the defendant is entitled to recover all of their attorney's fees for having to bring that motion. It's only if the anti-SLAPP motion itself was also frivolous. So if it was a legitimate defamation claim, they legitimately defamed somebody, and then the defendant brought an anti-SLAPP motion, but then the court said, no, your anti-SLAPP motion is the frivolous one. Then under those circumstances, the plaintiff can recover just the attorney's fees and costs that they incurred in defending against that motion. I hope that cleared it up a little.
Representative Lean?
Thank you, Mr. Chairman. I kind of want to jump back to page 2 where it says establish a mechanism in civil procedure at the bottom. Could you walk me through what does Wyoming have now for our citizens who are being challenged in any number of claims that would be covered under an anti-SLAPP law statute since we do not have anti-SLAPP?
Tamara?
Mr. Chairman, Representative Lean, we do have already in the rules of civil procedure in Wyoming, which are pretty much mirror of the federal rules of civil procedure, we have mechanisms for motions to dismiss. Already rules of civil procedure 12B6 allows for a similar analysis, which is that if the plaintiff has failed to state a claim upon which relief can be granted, which means even if all of the facts that they allege in their complaint are true, there's just not a cause of action. There's nothing the court can do about it. And so that will be dismissed already. And those are brought, generally speaking, a motion to dismiss needs to be brought by the defendant before or at the same time that they file their answer. So that's very early on in the case. And in my practice, I think that if litigants litigators in Wyoming had anti-SLAPP available to them, they would be more likely to add it to their motion to dismiss that they were already going to file in the case anyways. And then again, towards the later, as we were discussing earlier with Representative Chestick, there's an opportunity for litigants to file a motion for summary judgment after discovery. And a motion for summary judgment says, we know all the facts, there's no genuine dispute about what happened, and one side or the other is entitled to judgment just because that's what the law declares it to be in this case. There are several other types of motions to dismiss. The 12B6 failure to state a claim is the most common one.
All right. Any other questions, committee? You want to follow up, Representative Lean? Go ahead.
Thank you, Mr. Chairman. Shifting gears, I want to talk about the Uniform Public Expression Protection Act that you were speaking about. And I would like to know, could you just remind me, you talked about its protections. Is it all 5 of your First Amendment rights that it protects?
Mr. Chairman, Representative Lean, that's totally up to the legislature. You can determine, some states have only protected petitioning the government. Some have opened it up to all your First Amendment rights, and some have just expressed, a few of them. The most common are freedom of expression and speech, freedom of association, and the right to petition the government for redress. So those are the 3 main areas where you'll see it, but I've heard talk of perhaps whether freedom of religion might come into these at some point. I haven't seen any cases that myself, I haven't looked for them either, but I haven't seen any cases that address that specific one. But generally speaking, we're talking about freedom of expression and the rights to participate in the political process.
All right. In the interest of time, I don't want you to go through the state by state comparison, but I think it's important that we address the constitutionality issues with Washington and Minnesota. I think we're very much interested in the uniform law. That's why I think that's important, because if I understood you correctly, those states then went to the uniform law after their state statutes were found unconstitutional. So if you could just walk us through that part of your memo, that'd be great.
Thank you, Mr. Chairman. That is exactly correct. I'll start with Washington. The state of Washington enacted their strategic lawsuit against public participation act in 2010 originally, and they had based theirs on, they copied California's a little bit, but they notably changed some of the language, which required plaintiffs who had filed the original lawsuit to, when they were responding to anti-SLAPP motion, that they had to prove by clear and convincing evidence that their lawsuit was probable to result in a favorable decision for them, which the Washington Supreme Court in Davis versus Cox, I believe that was in 2015 or 2017, held that the structure of their scheme for that law effectively put the burden of determining what the facts of the case were on the judge, excuse me, rather than the jury. And in the usual course of things, lawsuits, especially those where people have a right to a jury trial, it's the jury that is the finder of fact. And so it's not, the judge determines what the law is, and it's 100% the judge's decision to say what the law means and interpret the law for that case. But the jury is the determiner of what happened. And so if they have to weigh the evidence and determine which party is right, that's the jury's job, not the judge's, in the general course of things. So this law, by saying that the the plaintiff, in defending against an anti-SLAPP motion, had to establish by clear and convincing evidence a probability of prevailing on the claim. The court said this is different than a summary judgment, because in a summary judgment, the court isn't deciding what the facts of the case were. The court is just saying, you guys aren't arguing about the facts, so we can decide the matter. And so that anti-SLAPP legislation was basically taking the fact-finding rule and putting it in the court, and that the Supreme Court said that's not constitutional. It violates their right to jury trial. It violates their right to due process as well in many instances. So that was struck down, and then in 2021, Washington enacted a version of the UPIPA. And also Minnesota is very similar. They had very similar language in their legislation that required the, excuse me, the court to weigh the evidence essentially and determine whether there was a probability or clear and convincing evidence that the responding party would be likely to win in the end. And that, of course, it goes beyond. The point of the anti-SLAPP motion is to not decide this on the merits because it's a frivolous lawsuit. If you have to go all the way to deciding the merits, it kind of defeats the purpose, and it, more importantly, runs afoul of the constitutional right to a jury. And so that would be the difference between the UPIPA, is that it doesn't ask the court to weigh the evidence. It asks just to decide in a summary manner what the law is and whether the law applies to the situation, rather than whether the facts decide it. That, if I have.
Thank you. The Uniform Act has been adopted in 16 states, correct?
Yeah.
And has the Uniform Act ever been challenged in the Supreme Court? Was that in your memo?
If there have been challenges, they have not been successful. I noted at least one challenge to Arizona's, which is similar in many ways. The UPIPA has a lot of similar the phases and the way that it functions, but the court that had received the challenge was the United States District Court for Arizona, and they have a longstanding law that they don't decide the constitutionality of state statutes unless they absolutely have to. So they declined to do that in that case. So there is some buzz out there that there might be portions of some of these acts that are that could be challenged, but I haven't seen any successful challenges yet.
Great. I see that in your memo on page, why don't I see page numbers? Page 11, it's page 6, it's up at the top. So page 6 has the legal challenge to the Arizona law. Thank you. Any other questions, committee? All right. Well, we appreciate all your research on it. We're not done yet. I think as we progress on this topic, we're definitely going to be leaning on you for your expertise that you have so far developed in this. It's definitely, there's a lot to it. It's definitely a complicated procedural matter, I think, for us to wrap our brains around, especially for, I think so for lawyers, but definitely for non-lawyers. There's quite a bit here. So thank you. All right. With that, I think we will jump into testimony from our Uniform Law Commission. So Mr. Meyer, let's let Allison in. And then I know that you introduced Brian Laney to us, but we'll bring him in separately. I want to start with just the commission first.
Thank you, Mr. Chairman, members of the committee. Scott Meyer on behalf of the Uniform Laws Commission and as one of Wyoming's commissioners. I really can't give a whole lot more than what the excellent work that LSO did, and I think applaud them for the work that they did do. I think one of the things, we talk about the pros and cons of anti-SLAPP legislation in general, but I think one of the biggest cons out there against this stuff is the fact that it's inconsistent application across state lines. So on behalf of the Uniform Laws Commission, we would encourage the legislature and this committee to look at specifically the Uniform Act. And I think, as been mentioned, it's already been adopted by several other states. Has been challenged once, not successfully. But I think that it addresses a lot of those issues that I think that we talk about within the cons, especially when it comes to procedural complexity. I think it has a much straightforward layout of how it works. But I think that one of the things that is different than I think even the proposed bill that was last year is that, and this is probably more for you, Mr. Chairman, and Senator Crago and Representative Chestic, but this focuses more on motion practice, which I think is more important, at least in the state of Wyoming, on how this works. I look at this and say, how can we make this as simple as we can and yet still protect all the interests that we have out there? I would try to address any of your questions, but I will tell you right off the bat, as I look through this stuff, I know that there was some questions, especially from Mr. Chestic, Representative Chestic, regarding discovery. And I think that at least under the Uniform Act, under 4D, they talk about that the judiciary has the discretion. And I think that's the important part of this thing, is to say, look, yes, we don't want to go gung-ho wild with discovery, but at the same time, we want to make sure that we have enough out there to make sure we can make an informed decision. And I think that in itself is probably really going to be burdensome a little bit on the judiciary to make sure that they get this right, because you're going to see a lot of people arguing about that, I think, at some point in time. And I will say also that as I look through this thing, I think Senator Colby had a question regarding fees, and it is designed to make sure that the fees for the one that's saying I'm getting sued wrongly, to have a chance to collect those fees. But it also has an opportunity to say, wait, time out. If we have a look at this and everything is right, that maybe you don't get all those fees. But it is kind of decide on probably on the little guy most, the guy that's trying to have to defend himself. And with that, members of the committee, I'd certainly stand for any questions. I'm no expert on SLAP or in this act. I mean, I've read through it and read it and understand it, but the little nuances, I think that'll be more borne out as we go through and we see a proposed bill.
Mr. Meyer, the thing about the Uniform Act that is very inviting to me is the fact, well, one, that it's been enacted in 16 states, but more importantly is the lack of challenge that it's had in the court system. Seeing that 2 other states reversed course and went to the uniform law after their states were challenged. That was my biggest concern when this legislation was introduced to us 2 years ago, was that it could be challenged. And there's a world of, there's a lot of unknown when you get into crafting this legislation on your own. So I think the fact that the uniform law is basically tested in 16 states makes me feel a lot more comfortable.
I think, Mr. Chairman, you're exactly right. And when you look at the process, and, I'm just finishing up a 3rd year of being a commissioner, but watching the process of how this goes, and it's not just something that's done over months, but usually over years, and the amount of input that they receive, not only from the commissioners, but from legislators, from judiciary, from academia, all that stuff to in there. I think that you're right, Mr. Chairman, that it really does make it a much better bill, and it is not near as easily challenged successfully.
Representative Chestic?
Thank you, Mr. Chairman. Mr. Meyer, thank you for being here. And I have to say, I also share the chair's preference for the Uniform Act. The way we did, the House actually passed the bill last year. I voted for it, but I like this bill better, to be honest. I'll be very frank. One of the things about the prior bill that confused me, I voted for it anyway, but I was still uncertain about it, was the concept in the prior bill was that, number one, you needed a new lawsuit. But number 2 is that the concept was of immunity, that rather than having a motion, the new statute granted immunity from suit, which is a weird concept in this context. And the explanation I got when I asked that question in this committee earlier this year was that the immunity was designed to establish this as a substantive right under Wyoming law, that would apply in federal court as well as state court. Therefore, it was trying to protect the anti-SLAPP rights, even if somebody's in federal court, because otherwise it's a procedural matter and the federal rules would apply in federal court. So this is an attempt to get around that issue. What is your reaction? Do you agree with that, or what is your reaction to that idea of using the concept of immunity to cement state rights in federal court?
Mr. Meyer.
Mr. Chairman, Representative Chestic, first I'll tell you, I agree with you on the whole term of immunity. It just seems foreign to me because it really doesn't apply to something like this. And I think that's why it's important with the motion practice that we have motions to dismiss, and maybe it's with prejudice or without prejudice. In this case, it would be with prejudice. But I think that those are the issues that I think we're most likely to deal with. I think from a federal standpoint, I have yet to be, even if it's federal rules of civil procedure, but if we had an anti-SLAPP statute, I would fail to see that the federal judiciary would not look at that and say, well, this is in Wyoming and we're going to apply Wyoming law. We may not file Wyoming procedures. We may have our federal procedures, but because this is a statute, I think they would definitely look at it.
Please go ahead, Representative Chestic.
Would it matter whether the basis for federal jurisdiction is federal question or diversity?
Mr. Chairman, Representative Chestic, I'm not sure that it would. Yeah.
Representative Lean.
Thank you, Mr. Chairman. Thank you for joining us today, Mr. Meyer. My question is about inconsistent application of the law. Could you give us an example where anti-SLAPP has been inconsistently applied?
Mr. Meyer.
Oh, Mr. Chairman, Representative Lean, I'm not sure I can. Because I haven't done near the much comparison stuff as LSO has done. But I will tell you that it just seems that every time we get into one of these things that we just try to do on our own in every other state, we're not sure what's going to happen if we cross the lines into Colorado, or if plaintiff comes from Utah or whatever, how that applies. And so I can't give you any specific examples, Representative. I just know that in my practice over the last 35 years has been that it just seems like that there's always these inconsistencies that cause a lot of questions on how we do it. Yep.
All right. Does your partner Allison have anything that she wants to bring to the table?
Mr. Chairman, I'm hoping she bails me out here.
She might bail you out.
She might help me too.
Good morning, Mr. Chairman. I hope to be both entertaining and efficient, as you stated. Allison Gee, Commissioner for the Uniform Law Commission on behalf of the state of Wyoming. I had a couple of comments I wanted to make. First, I think it's helpful to start with the purpose of bills like these. So I found some comments out of Texas, which doesn't have the uniform law, but I think captures the essence of what this body is trying to achieve. That the purpose is to encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government to the maximum extent permitted by law, and at the same time protect the rights of a person to file meritorious or good lawsuits for demonstrable injury. And so what the uniform law has attempted to do is to balance those interests so that we're protecting people who have good litigation that they want to file while protecting others against being harassed by wasteful litigation. And hopefully that's helpful to our court system as well. One of the items that I found most helpful is the limitation on discovery in this proposed act. And while has been represented or pointed out by representatives this morning, it could be problematic. I believe that our judges in application of this law would do a good job of balancing the interest of the litigants because they are subject to appeal if they don't provide sufficient access to discovery to determine whether the litigation should proceed or not. So I actually see that as a strength of this law. Those were the 2 points I wanted to address.
Any questions for Ms. G? Yes, Representative Lean.
Thank you, Mr. Chairman. Thank you, Ms. Gee, for joining us today. I didn't hear you mention religious freedom in your statement, and I was curious to know if you could cite any harm that could potentially come from leaving the fifth right out of uniform law protection.
Thank you, Representative Lean. Mr. Chairman, I have not, as my colleague, Mr. Meyer, stated, we did not participate in studying and approving this act. It came before the Uniform Law Commission, before we were on the commission. I don't know if there was testimony on that point, Representative Lean, and I don't have a position one way or the other on it. I do note that it is the only one of the 5, as you stated on the First Amendment, that was left out of that list. Perhaps it's that there hasn't been any litigation on that point. I'm unsure. Thank you.
Mr. Meyer.
Yes, Mr. Chairman, Representative Lean, I want to remind, I guess, the committee though, but if you look back at like the adoption of the Uniform Act for limited liability companies, or we looked at the Model Act for the corporations, Wyoming is very famous for doing its own home cooking. So there's, just because it's not in the Uniform Act doesn't mean that this committee can't decide that this is what we want to add.
Any other questions for our Uniform Law Commission? All right, committee. Thank you. Thank you, Mr. Meyer. Thank you, Allison.
Thank you.
Let's bring in Senator Brian Laney.
Mr. Chairman, if the senator could accept my request to promote him, then we can get him to join the meeting.
All right, there we go.
Welcome, Senator.
Thank you, Mr. Chair. Just for the record, Brian Lenny, State Senator for District 13 in Idaho. Happy to speak on this. It's been interesting listening to the testimony so far this morning, because it's what we went through for the last 2 years, all the same questions and everything like that. So I just wanted to talk briefly on our experience. You know, I spearheaded Idaho's effort to get this done. We started last year, my bill, anti-SLAPP bill, and essentially the same bill, the Uniform Law Commission bill. For the record, I don't like all Uniform Law Commission bills, but some of them are good and some of them I'm not a fan of, but this one I'm a big fan of. And we tried it last year. It died on the Senate floor. That was great. My mom was in the gallery and everything watching. And died for political purposes. We'll just say that. And then we came back this year with the same exact bill. And out of 105 legislators in Idaho, it only got 1 no vote. So we passed it this year and it became essentially the same act you're studying, became law in Idaho, signed into law last year. And it became effective January 1st of this year. So it's been law in Idaho effectively for about 5 months now. I wanted to get in just, again, I don't want to take up tons of your time, but I did want to get into more of the why I pursued this and who the bill protects. And obviously I can answer questions on what the bill does or any kind of, but I think this might connect some dots for you. So I learned about anti-SLAPP in 2021. I had no idea, the actual term itself, I had no idea what that was. I was actually speaking to someone at the Institute for Free Speech and about something entirely different. And he said, hey, you know, Idaho's one of the only, at the time, I know the number has changed, but he said, Idaho's one of the only states that doesn't have a anti-SLAPP provision. And I said, what is I don't even know what that means, anti-SLAPP. And I think in layman's terms, it's helpful to just look at it because this is what it is. It's just a bogus lawsuit, a sham lawsuit, like a lawsuit that can't stand on its own 2 legs. And a SLAPP lawsuit is something where the goal isn't necessarily the person bringing that lawsuit. The goal isn't necessarily to win the case, but to punish someone for exercising their First Amendment rights. So this does not get, this was a big problem we ran into in Idaho, as far in committees and stuff. People said, so wait, if we pass this, are people allowed to commit slander and defamation? And the answer is no. This is not about slander or defamation. It's about bogus lawsuits that clearly on their face are just ridiculous. Actually, one of the biggest anti-SLAPP lawsuits we see brought, and I'm going to give you an example of this here shortly in Idaho, like a real example of a suit going on right now, is public forums. I don't like something you said at the town hall meeting, therefore I'm going to sue you, that type of thing. So like I said, we got it done with bipartisan support. Obviously, if we only had one no vote in both the Senate and the House. And something that appealed to me initially on this when I started looking into it in 2021, 2022, is this, at least the uniform law bill has massive support from everyone from the ACLU all the way to, we have groups on the left, right, and center. And I think that's because no matter where you're at on the political spectrum, free speech obviously matters to everybody, and the First Amendment is something that we all hold dear. So this is one of those rare bills that didn't really have any formal opposition in Idaho. So that's kind of why I got into it. I just said, hey, I think Idaho should have something in place. I mean, at the time, it was only 18 states didn't have that. So briefly, and some of this has already been mentioned, briefly who the bill protects, it's just everyday people. We see these SLAPP lawsuits, I like to call them bogus lawsuits because it kind of makes more sense, but we see them brought by individuals and organizations. So just think powerful people with or organizations with a lot of money and time and resources who are trying to intimidate people or silence critics, for example. And like I said, these lawsuits aren't necessary. Some of these people in studying these, when you really go down the rabbit hole, as you guys are on, with this committee, some of these lawsuits aren't meant not meant to win. They're meant to make it expensive and or time consuming for the person enduring it, the defendant on the other end. And some people will bring the lawsuits knowing they're going to lose because the punishment or the process is the punishment. So they said, hey, we're going to lose in the end, maybe, but not before we run the bill up for hundreds of thousands or millions of dollars and drag this person through court for a year and a half. So again, these are the types of situations that an anti-SLAPP is meant to stop. And Mr. Chair, with permission here, I did want to read an email I got from a doctor in my area, if that's okay, who I think this directly will maybe help the committee understand kind of what type of case that we're dealing with here. Is that all right if I read that, Mr. Chair?
Oh, sorry. Go ahead.
Okay. So I weirdly received this email last week. And then the next day or 2 days later, I got invited to come speak to the committee here. So timing wise was perfect. But this is an email from a gentleman a few districts south of me. I did change his name, city he lives in, and business name, but everything else is original to the email. I didn't want to, put his name out there like that. So I got this email last week. Senator Lenny, I wanted to take a moment to write you a personal note of gratitude. My name is Dr. John Doe. I'm a doctor in town name and the owner of Acme Supply, a 20-acre commercial property. I also run the 110-year-old family practice, now in its 4th generation. Earlier this year, a developer received conditional approval from the city for a 96-unit housing project directly adjacent to my property. The approval process contained procedural deficiencies. The city did not follow its own statutes, and my company was never notified of the hearing as required by Idaho code. We were denied the opportunity to participate. I did what any property owner should be able to do. I filed a request for reconsideration through the proper legal channels, exercising my constitutional right to petition the government for redress of grievances. In response, the developer's attorney sent a letter threatening a tortious interference lawsuit, explicitly conditioned on the withdrawal of our administrative filing. The message was clear: stop participating or face litigation. Senator, that is the exact scenario your legislation was designed to address. Again, our bill went into effect January 1st of this year. Senate Bill 1001, the Uniform Public Expression Protection Act, gave my family and our attorney the confidence to stand firm, knowing that Idaho law now provides expedited dismissal and automatic discovery stay and mandatory fee shifting for meritless suits aimed at silencing public participation changed the calculus entirely. Your legislation turned a threat into a liability for the party making it. I wanted you to hear that directly from a constituent whose rights your work is actively protecting. Legislation like this matters most when it reaches the people it was written for, and it has reached us. If there's ever an opportunity to share this experience in support of the Act's continued application, or if I can be of service to you in any way, I'd welcome that conversation. Sincerely, Dr. John Doe. And I've gotten several messages like that, similar to that, just this year, from people saying, hey, and weirdly, one of them was from a lawyer saying, am I understanding this correctly? So I think another thing that would be important for the committee to do, which was very helpful for me, I worked directly with the state Supreme Court, with the administrative office of the Supreme Court. And I came to them very early on and I said, hey, here's what we're thinking about doing. How will this affect the operations of your court? And they just had little tiny tweaks that didn't change the substance of the bill. But I didn't want to just, if the bill passed, I didn't just want to come and say, hey, here's a new thing, figure it out. So as the bill passed and during committee, when it passed, when the governor signed it into law last year, they were fully aware of it, fully ready. And they did ask for 6 months for the law to take effect, because as you can imagine, putting something like this in place, you have to train the judges, the court staff, things like that. So, we did make that effective January 1st instead of what we usually do, which is July 1st. And I'm almost done here, Mr. Chairman. I appreciate your listening to me. There's more I could say. I think it's already been said, though. This bill, the Uniform Act, basically does 4 things. Like I said, it protects people's First Amendment rights, where they can engage in First Amendment rights, speak out at town halls, publish. I had one person getting sued because a business didn't like their Yelp review. So this protects people's rights to express themselves publicly without retaliation, things like that. One thing I think is helpful for everybody to know is this is a new term I learned also. I'm not a lawyer at all, but in the process of this, I learned there's something called litigation tourism, where people might want to have a bogus lawsuit or a sham lawsuit, and they'll say, well, we don't want to do it in Idaho because they have an anti-SLAPP provision, but maybe we could win over here because they have no anti-SLAPP protection. So this kind of puts up the guardrail saying, hey, if you're going to bring that kind of lawsuit, don't bring it to our state. Obviously, it minimizes, everybody's discussed that this morning, minimizes litigation costs early on. And I like to think of it, if you look at a bogus lawsuit, and these things can last years, they can be hundreds of thousands into the millions, it's dependent on the case. But if you look at a bogus lawsuit as a long highway, the anti-SLAPP, this bill just provides an off-ramp early on. So before all the costs get racked up, before we spend months and months and hundreds of thousands in court, again, as a non-lawyer, the way I look at it is this bill just says, hey, let's hit pause. Early on in the case, let's hit pause. And then the judge gets to decide, hey, does this case even have any 2 legs to stand on? Just on its face, if it's clearly absurd or ridiculous or bogus on its face, the judge is, again, layman's terms, the judge can say, this isn't even a thing. This isn't even a case. We're not going to waste time and money. And by the way, person who brought the bogus lawsuit, you now have to pay for the couple of days or weeks or whatever we did waste. So it just, it doesn't take away the job of the court. It doesn't take away the job of the lawyers. It does not take away the discretion of the judge. As was already discussed, it's up to the judge with the Uniform Act if they can pursue some sort of limited discovery. That came up in Idaho too. And we said, no, if the judge decides maybe there's some limited discovery, this bill allows for that. But at the end of the day, it's just another tool. We're just giving our judges and our lawyers another tool for their tool belt. They can use it. They can choose not to use it. It doesn't take away anybody's job. It just, I think, makes it easier in some cases. So that was a lot, Mr. Chair, and thank you for hearing me. And I'll hang out for questions if you want to do that. If not, I can log off here.
Yeah, thank you, Senator Lenny. It was a lot. Apparently, they don't have anti-filibuster laws in Idaho. 'Cause you're very good at the filibuster.
Yes, thank you.
Questions for the senator? All right. Well, thank you. We appreciate you zooming in and do appreciate your comments.
Yes, thank you, Mr. Chair.
All right. With that, I think we're at a place where we can move into public comment. So I've got a list of people on Zoom who want to comment, but let's see if we have any agencies wishing to comment. No agencies. All right. Representative Ottman, do you want to make any comments? Okay, come on up. We'll start with you. Welcome.
Thank you, Mr. Co-chairmans and committee. It's good to be here this morning and to approach this very important subject for the state. And we can see a year ago, there was only 10 states that didn't have anti-SLAPP or did have, and now there's 39. So we can see that it's a concern across our nation. I'm so glad to be here this morning to witness the work that will be and is being put forth for protection for those who have experienced possible lawfare, where procedural errors have set criminals free, where law teams are hired at great expense to win a case, where elections may curb an important decision, and to join other states that acknowledge how our legal system is being used to expose the attacks on our citizenry. The work that you are doing today and throughout this interim is paramount in developing and providing law that will stand up for those where anger, greed, desire to shut someone up, to break them, to take away competition, to make an example of, to destroy credibility, to discourage the weaponization of suing to obtain out-of-court settlements, often for large sums of money. The list is great, as is your task. The making of law is a great responsibility, especially considering that the cases we are speaking of are being presented and fought for by people in the field of law. Mr. Co-Chairman, both of you, my concern over this trend was brought a couple sessions ago. In an interim topic meeting, I was asked what topic I might bring. I said fraudulent lawsuits. It was not chosen at that time, but I was able to work with some skilled people and present bills to the body. This topic shows bipartisan support and support between both the House and the Senate. I am thankful for the opportunity to speak today and am hopeful that the weaponization of our precious First Amendment constitutional rights is not a trend, dangerous trend. I also hope that input will continue and our court system will also be blessed with a tool to eliminate some of the backlog and time spent. I wrote this today as I have so much to say and will just recognize that you are all sincere in your handling of this importance and will have discernment and wisdom as you go forth. Thank you, and I'll stand for any questions.
Yes, questions for Representative Ottman, Co-Chairman Washut?
Thank you, Mr. Chairman. Representative, glad you're with us today. Drove all the way down for this. Appreciate that. Can you give us any Wyoming examples where somebody in Wyoming was sued in a frivolous manner in order to deter their public participation? Do we have any actual cases here in Wyoming?
Representative Ottman?
There has been a case recently, but it was dropped. Let me see, the plaintiffs dropped it. And also, and I don't have a list of the names, but over the last 2 years, there's been many people that have called or commented on just arguments over fence lines and people that have taken their neighbor to court. And then they have both found out that this is not the best way to handle this. When we look at 39 other states, and I ran another bill this last year, First Amendment protections for medical professionals, because in that particular case, we do have people that have been either taken off of committees, taken off of responsible positions of importance and leadership. Places where research was not heard. And we do have those cases. So while there is, and especially going into this election, there's already evidence of many, many things that are going on. And bills like this can control some of that. It is my hope that not only are our First Amendment protections, and not just to say we need another law, but to say your weaponry of using First Amendment against people, being able to defame, being able to do all these things and call it a First Amendment right. If that can be seen quickly, I believe it will help in the court system as well to shorten up all the cases, but also the time spent. As the senator from Idaho said, we're talking years of cases. The one that was just closed was over a year. And so all of the time and effort spent, and we're always talking about the shortage of judges and court system, just the organization and the I hate to use the word streamlining, but to help that out, I believe would be advantageous. I believe that your work is going to be very, very important and very good because it affects not only individuals, but companies, but elections, but businesses, professionals, and our healthcare profession, of which we are really looking to bring healthcare providers into the state. So there's lots of reasons, lots of things.
Any other questions? Yes. Representative Kelly.
Thank you, Mr. Chairman. We've heard some positive appraisals of the uniform law, particularly its ability to withstand judicial scrutiny. Are you aware of any deficiencies in it that the Wyoming legislature should address?
Representative Ottman.
Thank you, Mr. Co-Chairman and Representative Kelly. The only thing that I would say that as I was listening this morning is that I hope that we're careful, and I wrote this down, let me see. I hope that we're careful that we make sure we screen the cases that where speech is a matter of public concern, and that we make sure that we hear the cases. A lot of this is new to me, just reading the materials last night and this morning. But what I'll say is that I believe that looking for a voice at the beginning of this to say whether or not there's merit or whether there isn't will be very, very advantageous to both parties. I believe it will keep both of them from experiencing things that could be very detrimental. And so I will continue to look at it and to ask those questions. We didn't, well, we did talk to the Attorney General's office and the Supreme Court. So this has been supported by both the House and the Senate. It has been supported by both Democrats, Republicans, and independents. So it is a concern, and I believe worth following through. So I said all that to say I'm not really sure about a lot of it, but I know I'm getting an education. I will continue to do that, and I know that this committee will as well.
Any other questions, Representative Lean?
Thank you, Mr. Chairman. Thank you for joining us today, Representative Ottman. If memory serves me correctly, in the 26th session in the anti-SLAPP legislation that you brought, there was a religious protection. Could you speak to that for just a moment?
Representative Ottman.
Thank you, Mr. Co-Chairman and Representative Lean. I honestly have the bill at my seat, but what I will say is that those protections went primarily in response to, and this goes to Representative Co-Chairman Washut as well, those go towards people that may have stood on a sidewalk outside of a clinic, may have written a brochure that says that they're pro-life, maybe a candidate that says that they're pro-life, maybe at a town hall where those kind of things are brought out for life. But as far as religion, so many times we hear religion should not be a part of this. Well, I would venture to say that 95% of us all have a religion, whether it be to say we have no religion or whether we have different religions. And that is a right that is protected and should be protected at all costs. It also can bring out religions that we may not be pleased with, but nevertheless, that is our rights as citizens.
Any follow-up questions or additional questions for Representative Ottman? All right, thank you. Moving to general public comment on this, or I guess we'll go to the governor's office. I guess we can hear from the governor's office. Welcome.
Thank you, Mr. Chairman, members of the committee. Good morning. Thanks for having me. First, I just want to say that I thank you for stepping back from this session, this last session, and putting this forward as an interim topic. This really gives more opportunity for extensive public comment, and it gives us the time to provide the thought and examination that this fairly complex bill, I think, requires and deserves. The governor's office supports this legislation. We do like it a lot better than the bill last year. It is very important that we protect people's rights of free speech, and we want to make sure that they are not harassed exercising that free speech through lawsuits. But as I believe Ms. G said, this is a balancing act, and you don't want the pendulum to swing too far the other way, because there are some valid defamation actions and some valid claims. And so I think we like this act because it really seems to put that balance right in perspective and protects really both sides. So the way the act is right now, governor's office really doesn't have any concerns, but we understand that we always want to consider particularly Wyoming issues. And I just want to address kind of two things that have been brought up today. And they are the two things that gave pause to the governor's office. And one was the concept of immunity. And I've had a chance to think about that a little bit since last year. And my understanding is, as you said, Representative Chestek, that the hope with this would mean that federal courts would actually apply the state's anti-SLAPP law. there is a difference in federal courts. Some circuits have and some circuits have not. And it is the Erie Doctrine, which says that in diversity cases, that a federal court will apply state substantive law, but apply federal procedural law. I don't know the answer to the federal question you asked, Representative Chestic, but that's the one. And so my question there, and I would start with, this is very complex, and I think research, if this is a concept you want to include in this bill, I would look to LSO and say, you need to do some research. I don't know. I did very minimal research, but I couldn't find a federal case that considered immunity in connection with anti-SLAPP laws. And I don't know that another state has that concept. But my first thought would be, this immunity is a procedural right. And so if the federal court's not going to consider states' procedural law, I don't know what it gets you. Sovereign immunity is a substantive right, but that's not what we're talking about here. Sovereign immunity is for governmental entities. And so I have a concern about that. And then I look at it and I think of immunities as applying to a particular type or group of people. You have spouses who have immunity from testifying at trial. You have you as legislators who have immunity for your actions you take. You have judges. You have diplomatic immunity, but that's all the character that they get that because of who they are and not what they did. If you apply immunity in this case, you're giving people immunity for what they did, which is the subject of the lawsuit. And I think that's very awkward. Not to say you can't try to apply that. And then the last comment there is, I just don't know the unintended consequences of giving this immunity. What are some other rights and privileges, and does it change this balance that the Act establishes? So those are my concerns with the immunity concept. I think this legislation works pretty well the way it is. And I just don't have any indication that it would help us at the federal court level. I think over 30, almost 40 states have passed this. I think the best thing would be to go to Congress and say, let's have a federal anti-SLAPP legislation. That's what we need. So, and then the second issue you brought up was the freedom of religion, and that's the other part that gave pause. The bill is really related toward communications, free speech, free press, petitioning. You're communicating something. It's not based off of acts or decisions. And I worry that freedom of religion brings in the concepts of acts or religion or decisions. And so that's not how the bill was created. So that's my concern there. It certainly, if you have a communication about religion, it would come under this act because it's a communication and you have free speech with regards to your religion. So to Representative Ottman's concerns about, flyers or posters or, those would all be free speech. So I feel like those would be covered. So those are the two things that gave us pause. And we feel like this bill addresses those concerns and really creates a very nice balance. But I will say on both of those issues, if you really think you want to put those concepts in, I would say more research would be necessary because I really did a very high level look into that. And so with that, I am happy to stand for any questions.
Any questions, committee? Yes, Representative Kelly.
Thank you, Mr. Chairman. Just to clarify then, it's redundant to have an added provision for religion because religious speech would be included under all speech. Is that what you're saying?
Mr. Chairman, Representative Kelly, freedom of speech, yes, would include any speech concerning religion. What I was saying is that freedom of religion allows you to conduct certain acts and make certain decisions. And I don't feel like that's what this Uniform Act was meant to address. Maybe it could, I'm not saying it couldn't. I just think that that's not what they were thinking about when they were putting this together.
Representative Kelly.
Thank you, Mr. Chairman. Could you then please specify maybe some examples of such religious acts that we'd be concerned that would get caught up in a religious amendment or provision in a bill?
Mr. Chairman, Representative Kelly, I'm thinking of something, and I'm not sure that I have all the facts of this case right. But I guess if someone was to say, no, I'm not going to provide you a service. I'm not going to make a cake for you because my religion says that what you don't abide by what I feel like are the terms of my religion. So that's an act. I've denied a service to somebody. That's not a communication. And so that would be the situation that I would have to think through to see if that really would work. That take that through from the act to the lawsuit to the anti-SLAPP motion and feel like if that would really work under this. I haven't done that exercise, but that was my concern.
All right, any other questions, committee? Thank you. Now we'll move into general public comment. Welcome.
Morning, Chairman. My name is Parker Jackson. I'm a staff attorney with the Goldwater Institute. The Goldwater Institute is a nonprofit public policy and public interest litigation organization. And so we practice all over the country on free speech type issues, limited government, public records, things of that nature that are designed to benefit the public. I really appreciate the discussion we've had so far this morning. I think this is a critically important topic. I think we're kind of all getting to that realization here. I appreciate the comments that have been made about the purpose of this effort. Some of you may remember from during the legislative session that I testified alongside a Wyoming mom by the name of Kari Cochran, who she was the subject of two frivolous lawsuits that were designed to curtail her speech. I regret to inform you that she's actually been the subject of a third matter that was unrelated from the first two, but that still implicated her speech. So that this continues to be an ongoing issue, even just since the end of the legislative session. There's been developments that demonstrate the need for this. The Uniform Act, as has been discussed, does a lot of great things. It's a great tool in state court. It checks almost all the boxes that you would expect out of an anti-SLAPP law, and those have been discussed, so I won't rehash all of those. But I do want to get directly at Representative Kelly's question as to what are some of UPEPA's potential deficiencies. This has kind of been hinted at, and I don't have all of the solutions to this, but it's something that I want to flag because I do think that over the next couple of meetings that we should have this serious discussion. And Mr. Chairman, you mentioned this is a complicated procedural matter, and that's really the crux of this is UPEPA is designed to provide a procedural mechanism to get out of a lawsuit. And there's an ongoing fight in the federal courts, both at the district court level and at the circuit court level, as to whether anti-SLAPP laws, including some that are based on UPEPA, are procedural or substantive. And the courts are kind of all over the map on this. It really is kind of a confusing state of affairs. And so I think that's what kind of motivated the bill that we saw last session, which was an attempt to kind of get ahead of some of this litigation and some of these court cases that we're seeing where federal judges are declining to apply even really good UPEPA-based state anti-SLAPP laws in federal court proceedings. And that's leading to not just litigation tourism, but forum shopping. The Erie Doctrine, as has been mentioned, specifically applies in diversity cases. And that means that if somebody in another state was to come in and sue a Wyoming citizen in federal court, that the courts would apply the federal rules of civil procedure before they apply any state procedural laws, including anti-SLAPP laws. And the 10th Circuit has considered this in the context of New Mexico's anti-SLAPP statute. New Mexico's is not uniform, but it does use a similar procedural mechanism. This is from a case called Los Lobos Renewable Power. The citation for that, for future reference, is 885 F 3rd 659. That's a 2018 case. And the court in that case said that their anti-SLAPP statute was, quote, nothing more than a procedural mechanism. And that's what we're trying to avoid here. We want to create a substantive protection that goes beyond procedure. And again, as I mentioned, that's not limited to non-uniform states. Just last year, there were 2 federal courts that found that UPEPA did not apply in federal court. This is a case called Salam v. Trump. This is out of the Eastern District of Pennsylvania. The citation for that is 350 FRD 14. And that is notable because that court said that UPEPA did not apply in its entirety, which is farther than some other courts have gone. And that's, again, because it's deemed to be procedural and not substantive. Also last year, the Federal District Court for the District of New Jersey, they took more of a piecemeal approach. This case is called Paucek, P-A-U-C-E-K, versus Shaulis, S-H-A-U-L-I-S. The citation for that is 349 FRD 498. And the court there found that some of the UPEPA provisions applied, but some of them did not. And I'm aware of some other cases where UPEPA has applied in federal court to varying degrees. But that's really what we want to try and address here is how can we take the best parts of UPEPA, how can we take the best parts of other anti-SLAPP statutes that have applied in federal court and make sure that we're not creating additional problems and additional incentives to go rush to federal court to try and avoid Wyoming state court protections. So again, I don't have all of the perfect answers today, but I'm happy to pass along some of those citations in writing if you would like. And I'm happy to stand for any questions.
Questions for Mr. Jackson? Yes, Senator Crago.
Thank you, Mr. Chairman. Thanks for being here. Super helpful. So have any of the states that have non-uniform laws also have the same issue regarding whether it's procedural or substantive in federal court?
Yes, Mr. Chairman, Senator Crago, it's been hit and miss. And it's kind of getting difficult to predict what the federal courts are going to do. Sometimes not to get too far into the weeds, but the U.S. Supreme Court has a case called Shady Grove that's kind of the modern structure for applying the Erie Doctrine. And what they're trying to figure out is, does the law at the state level address the same question that a federal rule of civil procedure addresses? And if so, they're not going to apply the state law. And that's the really shorthand version. And so what we want to make sure is that we're creating a new or unique substantive protection that goes beyond what the federal civil procedure rules do, which is why this immunity concept was explored, is because that's not something that is found in this context in the federal rules. To the point made by one of the previous speakers from the governor's office, I do think there is a Pennsylvania case. This is called Jakes versus Youngblood. Citation on that is 782 F sup 3rd 210. They used the framing of immunity and still called it procedural. So I don't know if immunity is a perfect answer either. But that was a characterization that the litigant made that the court was citing. That wasn't, as far as I'm aware, the immunity was not embedded in the statute. So we're going to have some work cut out for us to really create a Wyoming-based solution to try and tackle this problem.
Representative Chestik.
Thank you, Mr. Chairman, and thank you, Mr. Jackson. Very helpful. I do want to see those cases. I wrote them down. I hope I got them written down correct, but if you could email those to me, I'd appreciate very much. I'd like to read those cases. My question for you is, to me, procedures are contained in court rules and substantive rights are contained in statute broadly. Okay. I'm not sure there's exceptions to that, but is the fact that we're considering putting these rules into statute, does that have the courts considered that statutes are providing substantive rules and leaving the procedural rules to actual rules of court? So by putting into statute, does that by itself create a substantive right?
Mr. Chairman, Representative, I don't think that's a determining factor in the cases that I've looked at. Like I said, the courts usually look at is the state statute trying to address something that the federal rules address. And if there's overlap there, that's when there's going to be some tension. One of the things they look at in this Erie analysis is is it going to affect the substantive outcome of the case? Is it going to affect who wins and who loses? And that's what some of these cases are fights about the attorney fee provisions and the fee shifting provisions, which are generally deemed to be procedural. Because you can win and not get your attorney fees, or win and get your attorney fees. And so the courts are saying, well, if you can win and not get your attorney fees, then that seems more procedural. I think the biggest point I wanted to make today was that UPEPA does not necessarily solve the problem that we've raised. And it is a very new, like I said, both those cases finding that UPEPA didn't apply in federal court, at least in part, those were just last year.
Senator Craigo.
Thank you, Mr. Chairman. So I want to follow up, I guess, and go back. I mean, you said a few minutes ago that some of the states that also have non-uniform laws regarding this issue have had the same problems. Is that correct?
Mr. Chairman, I think so. The challenges that were mentioned earlier, those were on constitutional grounds. That was dealing with the jury trial right, and I've not seen that in the UPEPA context. I do think that there was an amendment to the bill that was brought during the session that would have addressed that concern, so it probably wouldn't have been struck down on that particular ground. But yes, there are some non-uniform. The thing with non-uniform statutes, as was mentioned at the beginning, is they really are all different. Arizona's, for example, is really unique because it's not only not based on UPEPA, it's the only one that applies, as far as I'm aware, to criminal cases. Most of these are designed to get rid of civil cases. And so it's really hard for me to categorize all the non-uniform ones in one way or the other, because they really are case by case.
Senator Craigo.
Follow up. Thank you, Mr. Chairman. I guess I'm just focusing more on the procedural versus substantive issue in federal court. And I think you'd said that some of the non-uniform have also had the same discussions and same issues when they went to federal court. Is that correct?
Yeah, Mr. Chairman, Senator, I think that's right. And that's because most of them use this special motion to dismiss or special motion to strike. And we want to get to a point where, yes, we have the procedural tool, but the procedural tool is being used as a substantive protection, not merely as procedure.
Representative Washut.
Thank you, Mr. Chairman. So it seems like this question of how do we protect Wyoming citizens if these cases migrate into federal court is yet unsolved. No one has clear direction for us. Would the committee be wise to pass an anti-SLAPP law that doesn't fix that piece of problem? Would we still be miles ahead to have a anti-SLAPP law that applied for state courts? And even if we can't come to a solution for the federal issue?
Mr. Jackson.
Mr. Chairman and Mr. Chairman, I do think having UPEPA would be better than nothing, because it would protect those cases that can only be brought in state court. But it does leave open those other cases, especially when you're talking about the First Amendment. That raises all sorts of, there's federal questions there. And again, the diversity cases we're talking about is, out of state versus in state or vice versa. So that's something that we'll need to think about. But it would protect at least against in-state litigants bringing state claims in state court.
All right. Thank you, Mr. Jackson. Appreciate you being here in person, coming all the way from Arizona.
From Lyman. Yes.
Oh, from Lyman. Oh, no, so you practice from Lyman, but you practice in Arizona.
Yes, Mr. Chairman.
Okay. Welcome.
Mr. Chairman, members of the committee, thank you for the time. You have a handout for me with a big buffalo on top of it. I'll be very brief. My name's James Halverson, Deputy State Director with Americans for Prosperity. As a simple-minded cowboy from Crook County, Wyoming, which is in Wyoming, who's more comfortable standing behind a cow than a microphone debating a very complex legal issue, I'm just going to give you a few of our thoughts. The previous legislation is a little bit cumbersome. I'll be the first to admit that. But this is a complex issue, as we've all seen right here. I would just offer a little food for thought, though, that just because a different proposal hasn't been challenged, I don't know that necessarily makes it better. But I would say that definitely makes it more narrow in its scope and protections. I'm thankful for all of the very, very smart people in this committee and in this room, and I know that we will we'll find a way forward that protects our First Amendment rights. And I'm looking forward to that. You know, in a time when roughly 24% of the households across our country are living paycheck to paycheck, this is a big issue. If people are scared to speak out, that limits our participation in our government. So this is extremely important. This is a form of cancel culture. We've seen it. We've seen examples right here in Wyoming. We've heard another one happen right here between the session and now. So this is very important. This is just a fast track process. We understand that, and we need that to help dismiss some of these cases. That will save not only those defendants money, that will also save the taxpayers money. And we're definitely in favor of that. It will also relieve some of the burden on our very overworked court system. And we think that will help everyone involved. Our government, as I previously said, requires public participation. And we at Americans for Prosperity are in favor of anything that helps move that forward and encourages that. So that's all I have for you. If you have any questions, I'd be happy to answer them.
Questions for Mr. Halverson? All right, thank you.
Thanks, folks.
Mr. Crossman?
Thank you, Mr. Chairman. Colin Crossman, Cheyenne, Wyoming, here in personal capacity. A couple of points. First, thank you all for bringing this issue up in the interim. This is something that I think that Wyoming has needed for a while. I won't rehash my experience with a SLAPP suit. It wasn't in Wyoming, but before I moved here. So I will also stress that, yes, I do agree that UPEPA is better than the state of affairs. However, I do think that it has some gaps, going to one of the representatives' comments earlier. One of those gaps being the thing that was discussed at length, which is the lack of activity in the federal court. I think that the Los Lobos decision in the 10th Circuit gets to that. So that's why the immunity provision was discussed in the previous piece of legislation, HB 103, I think it was. Immunity gets to a couple things. One of those is it is a substantive right, and it does tack onto the existing procedural aspects that the court uses. So it doesn't need to create new procedures. We'll just use the procedures that exist. That's effectively why immunity was discussed, because the courts understand how immunity works. And one of the previous presenters mentioned that, that it's unclear whether or not the federal courts would take in the state grant of immunity. At least two cases in the 10th Circuit have shown that should not be a concern. The first case being let me find it up at the top of the page here. Oh, come on. Quintana v. Dodge in 10th Circuit. It's that's the wrong citation, but it was in 2024. Get that citation for you. Well, I have the docket citation 23-1113, where governmental immunity in Colorado was deemed to be a substantive right. There's a second case, actually, a more interesting one, because it comes out of Wyoming, and this is Roberts v. Jackson Hole Mountain Resort in the 10th Circuit in 2018. This one talks about it's not an immunity per se, but it was a substantive right that was granted over the assumption of right for skiing, dangerous skiing. And the 10th Circuit held that grant of exclusion of liability was a substantive right. So there is reason to believe that the 10th Circuit would actually be more, because of Los Lobos, more negative toward the procedural component, but potentially more positive toward a grant of immunity. And if immunity is a fraught term because of what it seems to imply, there are ways to get at that without specifically calling it immunity. But the grant of immunity for that, I think, is potentially the right way to go, or at least attempt to have a serious discussion about including it. The other area I think that UPEPA might be a little bit lacking is its explicit exclusion of commercial speech. It gives an example of a mattress store where a mattress store's false statements would not be, where UPEPA would not be available to them. Well, are they false statements? We don't know. We haven't done anything yet. If they turn out to be false, should they have the fee shifting fee shifting open to them? If they are false, then it's fraud. It's not protected. It wouldn't qualify for immunity anyway. But if someone can go to a corporation and just hit them with frivolous lawsuits for that, that's just leaving them open to the same thing that we're trying to protect citizens from. And one of the big aspects that is unique to Wyoming that some of the other states don't have is that we actually have a very large number of entities here that are where the people are not necessarily here. We like to have entities here. We get a lot of money from them, tax revenue and other things. And we are the second most popular state for incorporations. In fact, what was one of the things that Wyoming did that wasn't uniform, which is we invented the LLC. So protecting those entities, having them move here is good for the state, and making sure that they are protected from these kinds of lawsuits as well as our citizens is important, I think. Leaving them in the cold doesn't really look good to me. So I'll leave it there and open myself for questions.
Representative Chestik.
Thank you, Mr. Chairman. Thank you, Mr. Crossman, for being here. And I do recall our conversations in a room like this earlier this year about the immunity issue. My question to you, and I haven't thought this through completely. I want to read some of these cases that you were throwing at me. I'm interested in them. But my question is whether or not the immunity solution that you came up with would actually work in cases involving federal question. So to me, I don't want to get too deep into the weeds here, lawyer to lawyer, but so in a diversity case, it is state law that provides a substantive rule for decision, right? So in a diversity case, the state substantive law applies and the immunity would probably apply there. It's a diversity case. Federal question is federal law that provides the rule of decision. We're deciding the case based on what the federal rules are, the federal law. Wouldn't federal substantive law be supreme over state law? So would the supremacy clause wipe out the immunity issue anyway in a federal question case?
Mr. Crossman.
Thank you, Mr. Chairman. Representative Chestik. I'm going to answer in a very annoying way and say yes and no. No, the supremacy clause would not apply because it wouldn't apply. When you're talking about defamation, there is, to my knowledge, there is no federal cause of action. So you're not going to be in the state law anyway. So the state substantive right wouldn't be at issue. It just wouldn't, because in order for the federal court to be looking at the state law to begin with, it would have to be a state law question. So the supremacy clause wouldn't override it because the question wouldn't even be on the table. If it were on the table, I would say that yes, the supremacy clause would apply, but I don't think we get there because except in a couple of very specific and narrow circumstances, there aren't the federal torts that would read in the state immunity to begin with. So,
any other questions for Mr. Crossman? Senator Craigo.
Thank you, Mr. Chairman. Thanks, Mr. Crossman, for being here. On the Jackson Hole case, we must be talking about the Recreational Safety Act. Is that it? So I guess my follow-up on that is, do you know at what stage in the proceedings the case was decided? Was it on a motion to dismiss? Was it at the summary judgment stage, or did we go all the way to trial?
Mr. Crossman.
Yeah, thank you, Mr. Chairman. I would have to go further into that. I just called it up while we were sitting in the room in response to previous testimony. So I skimmed it, but they do get deep into the facts. So it was probably at a summary judgment stage and not just at a motion to dismiss. But I don't know if it was a full trial at that point. Oh wait, district court grants a summary judgment. Yeah.
follow-up, Mr. Chairman?
Go ahead.
So one of my follow-up questions on that, Mr. Crossman, is, I mean, one of the points of the legislation we're looking at is to stop the process early in the process, right? And so although they agreed there was immunity, they went through discovery. I mean, they're probably 2 years in by the time they get to summary judgment in federal court. I'm just wondering if the difference between immunity and UPEPA is actually going to make any difference at the federal court anyways, because we can't override their procedural rules. That's what the federal courts are saying, is their process is going to play out how their process plays out. They may still fall in line under our substantive law. I'm just having a hard time rationalizing that. And I should have asked Mr. Jackson as well, how that would work. I mean, even if we do provide some sort of immunity, let's say we create immunity, does that slow the process down in federal court? Does that really get where we want to go? Does that question make sense? And could you help me out with that?
Mr. Crossman?
Yeah, thank you, Mr. Chairman. So in federal court, yes, they're going to use their procedure, and if they don't, if we grant the immunity, or if we give the immunity, they're still going to use their procedure. That we might not get everything we want, but we probably can get more than nothing. And right now, with UPEPA, I believe that with any procedural or eerie vulnerable legislation we pass, we basically would get nothing. So we might get all the way to trial, even for some of these things. But this is yes, I fully admit that bringing in immunity here is an innovation. To my knowledge, no other state has put immunity in this context, and that is the innovation. That is what would be special here, and it would have to be tried. People would have to push it in federal court and see what happens. But at least in the qualified immunity case, in governmental immunity case, those can be and are routinely dismissed at the motion to dismiss at the 12B6 stage rather than a summary judgment later. And so at least the capacity is available there, whereas it isn't for a pure procedural method.
Mr. Crossman, are you aware of any UPEPA states instances where an anti-SLAPP motion was brought and you think that the case should have been dismissed and it wasn't sufficient enough under a UPEPA framework?
Mr. Chairman, I am not aware of that, where I guess the facts would have should have provided for dismissal, but this did not. I'm not. So I am not making the argument that UPEPA in a state court context wouldn't function potentially acceptably. I haven't studied it that well. I think that it is definitely better than nothing. It is better than other state laws. I think that UPEPA is possibly better than some of what the other states have. And I do think that yes, there are striking out on your own does create problems. You might go a little too far, and you could be unconstitutional. UPEPA would cabin that at least, and so you're not going out of range. But does that mean it gets everything that is unique to our situation here? I think that it does not.
Any other questions for Mr. Crossman? All right, thank you. Ms. Lance, I think you're the last one in the room before we move to online testimony. We're running just a little bit behind, so bear that in mind.
I'll be pretty quick. Mr. Chairman, Mr. Co-Chairman, members of the committee, my name is Beth Lance. I'm here today on behalf of the Wyoming Trial Lawyers Association. As an association, we have had somewhat of an opportunity to look through this proposed uniform piece of legislation for anti-SLAPP, and we certainly support fully the idea of protecting First Amendment rights for Wyoming citizens, and we support generally having anti-SLAPP legislation imposed here in our state of Wyoming. We certainly prefer the starting point, I think, of this uniform law. It, I think, creates a very good outline for us to work off of. And I believe that it would be potentially overcome some of the constitutional concerns, and otherwise which I think would be a good way to go in order to create a lasting piece of legislation. Just a few concerns I wanted to bring up just from the Uniform Act overall that we would just like to bring to people's attention. One of the things that is not defined within the Uniform Bill is what a matter of public concern is. And I think maybe defining that would be really helpful. I don't know that that's defined anywhere else in our statutes either. So that would probably be something to consider, making sure everyone understands what that means under this legislation. Additionally, there are a lot of rules, procedural rules laid out within this piece of legislation, which we already have rules of civil procedure. And I think it could make it quite confusing for courts to be creating new rules of civil procedure within this instead of just using our existing rules of procedure, which allow for all of the same dismissal rights and all of that already under, as you've heard here today, Rule 12 motions, motions for summary judgment, all of that already exists. And so I think it can become confusing when those rules of procedure are changed or listed throughout. Additionally, there are some exceptions written into this uniform rule. I do think we would have suggestions for potentially making it more clear by adding some additional exceptions. Looking at other states like Texas and Washington, they've gone much further with being clear about what kinds of lawsuits do not fall under this, just to be clear to the courts, such as insurance contracts, common law fraud, personal injury, those kinds of cases, just to be clear that we are keeping this to protection of these First Amendment rights and being sure that that is what this legislation is addressing and we're not overreaching. But overall, those are really my only comments that I had here today. And we certainly support this and look forward to hopefully working with everyone involved to create some good legislation.
Questions for Ms. Lance? Yes, Co-Chairman Walsh.
Thank you, Mr. Chairman. Could you supply us specifics on, I think you described them as procedures that are already exist in civil law that are recreated slightly differently in UPEPA? Could you maybe email us later some specifics of which ones exactly you think the existing rules were adequate for?
Ms. Lance.
Mr. Chairman, Mr. Co-Chairman, absolutely. I do have them outlined here, so it'd be very easy for me. I just, in the interest of time, didn't necessarily think everyone wanted to go through each of them. But within the uniform rule, as listed now, sections 4, 6, and 7, 8, 9, 10, and 11, or sorry, 8, 9, 10, and 12, all I believe are already covered sufficiently under our current rules of civil procedure. So I will certainly outline that, and I'm happy to email that to the committee.
Great, thank you. Representative Chestik.
Thank you, Mr. Chairman. Thank you, Ms. Lance, for being here. I assume that I do want to receive that same email about the rules. Do you think that we don't have a bill draft yet? I think one of the things we're going to hopefully do at the end of the meeting is ask for a bill draft. If the bill draft simply refers back to the Wyoming Rules of Civil Procedure, can that solve most of these problems of any potential conflicts?
Ms. Lance.
Mr. Chairman, Representative Chestik, that is a good question, and it's certainly something I've been sitting here this morning contemplating. I'm wondering if that would make it easier then when these cases are then switched over to federal court, that it would appear more substantive and less procedural. And so I'm wondering if that actually helps us with the Erie Doctrine. So I don't know. I would have to do more research on that, but it has occurred to me that maybe that would potentially be more problematic than helpful.
All right, thank you, Ms. Lance.
Thank you.
We're going to move to online testimony. We are 25 minutes behind, so I am going to limit online testimony to just a couple of minutes for each of our folks. So if you're listening and you want to testify online, I've got 5 of you signed up, but we're going to limit you just to a couple of minutes. So bear that in mind when your testimony begins. We'll start. Who did you let into the room? I was going to tell you to start with someone and just go down my list, but
Mr. Chairman, I have Mr. Keating online as well as Mr. Schriftman.
all right, Mr. Keating, go ahead.
Yes, thank you very much for allowing me to speak today. I appreciate it. I just wanted to cover a few things. I'm not going to try to repeat anything that I've heard earlier. There are actually 40 states that now have anti-SLAPP laws. We do a scorecard of all the states, and currently 60% of the population now resides in a state that has a grade, according to our scorecard, of A or better. 2/3 of the population is covered by a law with a B grade or better, and 89% of the population is covered by some form of anti-SLAPP law, including every state bordering on Wyoming. We've already heard earlier from Senator Lenny, there's strong bipartisan support across the aisle. Every major group supporting free speech nationally supports this, including my group, the Institute for Free Speech, FIRE, the Foundation for Individual Rights and Expression, Institute for Justice, etc. I would want to point out that UPEPA itself was modeled on the best state laws when they were drafting it. So it's not something new. It took a look at the most successful state laws and tried to adopt many of those provisions, including laws in Georgia, Texas, Nevada, Oregon, Tennessee, Oklahoma, Kansas, and Vermont. Regarding paying of attorney's fees, I heard some questions earlier on. I would like to point out that it's actually symmetrical because the person who filed the frivolous lawsuit or motion is the one who has to pay. So if you look at the UPEPA model, if you file a frivolous anti-SLAPP motion, then you have to pay. Likewise, if you succeed on the anti-SLAPP motion, that means the lawsuit itself is frivolous, and therefore the person filing the lawsuit has to pay. I've heard a lot about this applying in federal court. Look, I think it's clear no one knows the answer, but I will provide 2 important pieces of information to the committee. There are 2 states that have added an immunity provision, immunity from lawsuit, if you're making First Amendment protected expression. It's not a general grant of immunity. It's just immunity for protected expression. So that means it's non-defamatory. Ohio has added that to its version of UPEPA, and Pennsylvania has as well. In my opinion, the Pennsylvania provision is the best written immunity provision in the country. And if you want to go in that direction, I can put you in touch with one of the experts at, I think the firm at Ballard Spahr, who was helped the legislature draft that provision. It has not been tested finally in court. And the case cited earlier, frankly, is not being litigated terribly well. So basically, those are my comments to the committee, and I thank you for doing this interim joint study committee. I think you've covered a lot of great ground this morning. Thank you very much.
Thank you, Mr. Keating. That was perfect. Keeping it just at a couple of minutes. I do appreciate that and some helpful information. So thank you for your testimony. Any questions, committee? All right. Mr. Schriftman.
Yes, Mr. Chairman, can you hear me?
We can hear you. Go ahead.
Okay, my name is Ross Schriftman, citizen Casper. I'm representing myself. I am in support of the legislation to create a more fair and balanced approach to legal actions related to the rights of parties in relation to public speech. There has been an increase in legal activity that has created a chilling effect on our rights and our ability and desire to speak out to our elected officials. This has been referred to as lawfare. On the national level, citizens who brought forward claims of massive voting fraud in the 2020 presidential election faced unrelenting legal attacks, costing them significant funds to defend their rights as well as disturbing patterns of disbarment of their legal counsel. On the local level here in Wyoming, subtle threats of lawfare have been insinuated when citizens are looking into potential mismanagement or cronyism using our public funds. The message is clear. Do not pursue your complaints or make statements that we deem untrue, or we will haul you into court. On the state level, a scenario can happen where a citizen makes a public statement claiming that a certain elected official is bought and paid for by out-of-state interests because of support or opposition on a piece of legislation. If a defamation case is brought forward by a politician, the citizen should have proper recourse to have a fair and balanced opportunity for consideration to dismiss the plaintiff's case without a lengthy, expensive, and time-consuming process. Such legislation with common sense provisions is essential to protect our rights of free speech as guaranteed by the First Amendment of the United States Constitution. And it was mentioned about religious speech. Just give you an example, there have been citizens who have posted on their social media Bible verses and ended up either being hauled into court or being threatened. So I believe this legislation would include that. And I thank you for your time and your effort on this, this important subject.
Any questions for Mr. Schriftman? All right, thank you.
Thank you.
Who do we have next?
Mr. Chairman, next we have Ms. Prather online.
Welcome, Ms. Prather.
Thank you, Mr. Chairman. Thank you, committee members. My name is Laura Prather. I'm a practicing First Amendment lawyer and have been involved with the passage of anti-SLAPP laws in a number of different states, was an advisor to the Uniform Law Commission in developing UPEPA, and I'm actually working internationally to get these sorts of protections in the EU and the UK as well. So many of the testifiers earlier today have already explained to you that really what anti-SLAPP laws do is they recognize that the process of filing the lawsuit is actually the punishment here, and these laws are an effective way to short circuit that sort of punishment. I'm not sure that y'all have a clear understanding yet of the history of anti-SLAPP laws. They actually started in 1989 was the very first law that was passed. And the reason for one of the committee members asked about inconsistent applications, one of the reasons that there have been inconsistent applications is because there was a hodgepodge of laws passed between 1989 and 2020 before the Uniform Law Commission developed UPEPA. Once UPEPA was developed in 2020 and the 16 states that have adopted it have come into fruition, it's been really a wonderful way to have some consistency in the application of the laws. And the ULC process is one that Mr. Keating just mentioned is a really thorough process. They actually spend an entire year deciding what areas they want to try to draft uniform laws in, and then they spend 2 years studying the laws in all of the various states to pick the best of the best and really create the gold standard in protections in this area. And that's what the Uniform Law Commission did here. Then they present it to the commissioners, and the commissioners then vote whether or not they're going to actually enact and adopt these laws to roll out to the various states. There were a couple of questions on the scope of the law. Obviously, the broader the scope, the broader the protection. I'm not sure that religion was singled out as not being included in this. I think there is an ecclesiastical abstention doctrine that may or may not have been something that was considered, but things like the right to life, I can tell you in Texas, the right to life folks have been protected under the anti-SLAPP laws when they speak about abortion. And so those communicative activities are certainly protected in the religious setting. The fees issue that Mr. Keating addressed, he was absolutely spot on talking about the symmetry of it, because the symmetry is if you file a meritless lawsuit and if you file a meritless motion, either way, fees will be awarded. They're out of the 40 states that have anti-SLAPP laws. There is only one state, and that is Florida, that is a straight loser pay, and nobody uses that law for exactly that reason. It is not a symmetrical law. The reason you want to have this mandatory fee award is so that it will provide a deterrent effect for those people who think they're going to be able to use the court system to harass people and may think better of it if they know that they're going to be on the hook for the attorney's fees. It also helps, quite frankly, create an environment where there is judicial economy. The courts are not going to be overloaded with these cases if somebody knows there is a penalty to bringing a meritless case that is particularly targeted at somebody's constitutional rights. The last thing that I wanted to address was the examples. I know that y'all were looking for examples coming from your state. What I can tell you is these examples will come out of the woodwork. People, when we adopted the law in Texas, there were so many citizens that came forward. I mean, literally dozens and dozens of citizens that came forward to testify about their personal experiences in this area. People that were Yelp reviewers, investigative reporters, domestic violence victims, the Better Business Bureau for posting their ratings. The amount of people that have been impacted by meritless lawsuits that are brought for the purpose of trying to silence them in a way that is not consistent with what the courts are there to do is truly enormous. And y'all will see that when it comes time to hear from witnesses. But those witnesses and those examples exist. The First Amendment Watch group is now the very first group in the U.S. that is tracking SLAPP lawsuits throughout the U.S. And you can look on their website to see just the volume of SLAPP cases that exist. And it is absolutely it's staggering, quite frankly. That's all the statements that I have. And I was trying to just address those things that hadn't been addressed previously, but I'm happy to answer questions.
That was perfect. Appreciate that. Co-Chairman Washington, go ahead.
Thank you for joining us today, Ms. Frazier. I'm wondering about this question came up from the Wyoming trial lawyers about a matter of public concern. If you're aware of a good definition for that type of terminology, would you email that to us, please?
Yeah, I would be happy to, but I'll tell you, we addressed this exact issue both in Texas and in the Uniform Law Commission process. And in Texas, what we did, we had a definition of matter of public concern, and we actually revised the law to pull back and really rely on U.S. Supreme Court precedent. Snyder versus Phelps is a U.S. Supreme Court law that specifically addresses matters of public concern. We have that incorporated into our law in Texas, as well as a couple of other qualifiers. You'll see that in the Uniform Law Commission's advisory notes. It talks about that exact issue, and I'd be happy to send you all of that material. One other thing to address on the trial lawyer testimony, I know that there was some mention of adding some additional exemptions. I would only caution on adding those additional exemptions if you're going to add things like fraud, personal injury, those things that you definitely consider adding an exemption to those exemptions for communicative activity, because we have seen problems with creative pleaders pleading fraud claims against media for their investigative reporting, for example. And of course, that would be something that anti-SLAPP laws would want to address.
All right. Thank you for your testimony, and we'll look forward to that email.
Thank you.
All right. Next.
Mr. Chairman, up next, we have Miss St. Louis.
Welcome, Ms. St. Louis.
Thank you. Mr. Chairman, members of the committee, thank you for your time this morning. I will be reading my testimony because I am currently in litigation. My name is Michelle St. Louis. I live in Casper, and I'm currently a defendant in a defamation lawsuit stemming from statements I made publicly regarding a congressional candidate during a prior election cycle, including statements based on my faith. Because that litigation is ongoing, there are limits to what I can discuss today. However, I want to share with you the practical realities and the broader concerns that lawsuits like this can create for ordinary citizens. Regardless of the ultimate outcome, defending this type of case is extraordinarily expensive and time-consuming. For many Wyoming residents, the cost of defending themselves in court can quickly become financially devastating, even when they ultimately prevail. The reality alone creates the chilling effect. When citizens fear that speaking publicly about political candidates, business experiences, or matters of public concern could result in years of litigation and overwhelming legal expenses, many people will simply just choose to remain silent. And that concern extends far beyond my individual case. Wyoming has a long tradition of valuing independent thought, open debate, and the free exchange of ideas. Whether discussions occur at a coffee shop, at a town meeting, on social media, or during election season, citizens should not live in fear that participating in public discourse should financially ruin them. This issue is especially important in the context of elections and political speech. Our system depends on voters being able to openly discuss candidates, question public figures, share opinions, and debate issues that matter to them. Even strong disagreement and criticism are part of a healthy democratic process. In addition, many Wyoming citizens hold deeply rooted religious, moral, and political beliefs that may not always align with others. Regardless of viewpoint, people should feel secure in their ability to express constitutionally protected opinions without fear of being buried in costly litigation. I believe Wyoming should carefully consider meaningful anti-SLAPP protections that discourage the abuse or retaliatory lawsuits designed to primarily to silence critics through the financial pressure rather than to resolve legitimate harm. Any legislation should provide an effective mechanism for courts to evaluate these cases early, protect legitimate First Amendment activity, and allow wrongfully targeted defendants to recover the legal costs incurred defending protected speech. At the same time, truly defamatory and knowingly false statements should remain actionable. Responsible protections can preserve both reputational rights and constitutional freedoms. Mr. Chairman and members of the committee, this issue is larger than any one individual case. The question before this body is whether ordinary Wyoming citizens can realistically afford to participate in public discourse when the threat of prolonged litigation hangs over them. Thank you again for your time and consideration on this important issue, and I would be happy to answer any questions to the extent that I am able, given pending litigation.
Any questions, committee? All right, no one wants to touch that pending litigation, so you're fine. Thank you.
Thank you.
We have, I believe, one more. Or that's it? All right. We will close public comment. Committee, I don't recall exactly how we've done this in the past, but what I think would work really well, what I prefer to do, at least is what I see works well on committees, is that as we conclude each topic, we'll take any motions for any further action that we want from LSO, whether that's drafting a bill, producing research, whatever it might be, rather than wait until the end and try to remember everything. We'll just take it as it comes. So with that being said, are there any directives that you would like to discuss on this matter, Representative Chestick?
Yes, Mr. Chairman, I'd like to make a motion to ask LSO for a bill draft for an anti-SLAPP statute based on UPEPA, tailoring, of course, to all Wyoming procedures, but that's my motion.
Okay. Second. And it has been seconded. And just as a reminder, committee, this is just a motion to bill draft. It'll just be at the committee's pleasure as to whether we move forward with the draft, but then you'll obviously vote on that legislation, whether it should advance or not later in the committee process. That will require a majority of both bodies, but just to sponsor an idea at this point in time, that just requires a simple majority. All right, is there any discussion on this motion?
Question.
All right, all those in favor signify by saying aye.
Aye.
Any
Aye.
opposed? All right. Additional directives. I did want to see one thing from LSO on the issue of freedom of religion. I don't know. Obviously I know what UPEPA looks like, but I don't know what other states look like in terms of adopting UPEPA, whether that's been addressed by any other state, found its way into the statute. Mr. Fuller, you look like you want to say something.
So, Mr. Chairman, not necessarily specifically to that question, but to the question of, is there redress should the government, say, substantially burden religion by saying that, you can't take this action, this religious activity. And I don't recall if it was 2024 or 2025, Mr. Chairman, but the legislature did enact a state religious freedom restoration act. that does provide legal recourse if the government substantially burdens religion. How that interacts vis-a-vis this particular topic, I would need to give some more thought to. But for anyone who is interested, that act, those statutes begin at 929-101.
I think the co-chairman knows a thing or two about that. So then let's just do this. Let's look and see if there are any other states that have addressed it in their anti-SLAPP legislation specifically. And if not, that's fine. Then that can be the end result of that research. And then why don't you think some more about the interaction between the the Restoration Act and if we were to move forward with UPEPA? And we'll just look for a report from you guys on that. Anything else, committee, on this topic? Representative Webb?
Thank you, Mr. Chairman. Somewhere along the lines, I would like to see an issue addressed that we, on one side of the, in one chamber, we have passed a bill twice. That bill has been held up by the number one committee on the south side of the Capitol twice. But I don't know why that has been held up. It's never been heard. And I think if we're going to address a problem, we need to know what the issue is with one side of the chamber. Thank you.
I think that chamber's in the west. Just for clarification purposes, that chamber you're referring to is in the west, not the south. But we are the Western Chamber. Does that clear everything up? Senator Kolb?
Yeah, thank you, Mr. Chairman. Just to address that, that's why we're here. That's why we're here with both sides in Judiciary to work this out. That's the purpose of this, to be clear. There's a lot of other issues. I would suggest you go back and look at the video. It was all discussed fully on what the issues were. But we're here to fix that and get through it and make some legislation that works and we can both agree to and the governor can agree to. Thank you, Mr. Chairman.
Yeah, and I'll just say, because I really pushed for this topic to come forward as an interim topic, recognizing the need for this legislation, but more importantly, recognizing that it needs to be done right. So the legislation that came across to the Senate side was, a lot of those questions have been asked today. One of them was about immunity, for example. There's a lot of questions about immunity and whether that was the right way to approach it or not. And that's something that can be fleshed out in this process. But speaking on behalf of the Senate committee, we feel it's a very important issue. That's why it's here. We just want it done right. That's all. Any other directives for the committee? No? All right, with that, let's go ahead and take a 10-minute break, and then we'll come back and we'll dive into escape from adult community correctional facilities. Thank you. All right, committee, are we ready? Are we live? We are back. And we are ready to move forward into our next topic, which we have for 10 a.m. But I feel pretty confident, committee, that these next two topics we'll be able to make up time on, so we should get back on track. Next is escape from adult community correctional facilities. We have Director Shannon and do we have Director White? All right, perfect. Director Shannon?
Mr. Chairman, committee members, I'm Dan Shannon with the Wyoming Department of Corrections. I want to thank you for giving me a few minutes to review this interim topic subject. And Mr. Chairman, I'll do my best to get you back on track. How this came about, I would like to start by saying the Department of Corrections contracts with 3 adult community correction center. We have one in Gillette, one in Casper, and one in Cheyenne. These are transitional centers that confines individuals in the evening, provides opportunities for work, and gets them back. These are fairly successful programs. Normally, we average about 74% success when these individuals are transferred back in. The summary of the proposed interim topic, and we're talking about Wyoming Statute 713-402, it's determining inmates' ineligibility for parole. It serves 2 purposes. It clearly states it determines inmates to be parole ineligible for those who have made an assault with a deadly weapon upon any officer, employee, or inmate of any institution, or escaped, attempted to escape, or assisted others in an escape of an institution. The proposed language, committee, I'm not asking to change the intent, and I'm certainly not asking to increase any penalties. I'm just trying to clarify this law and make it more fitting for our needs in our correctional center. Why are we here? This is a policy decision that I would ask for the legislative body to consider the following recommendations to 713-402. Under the current wording, its ambiguity exists as it relates to parole and ineligibility. The recommended amendment adding the language has been convicted in the district court or found by a final determination in the Wyoming Department of Corrections administrative hearing process. It'll clearly establish the legislative intent. And that intent was that if an inmate attempts to escape from another or any institution, upon its final administrative findings, regardless of where an inmate is serving his or her sentence, the inmate is in a parole process. Under the current statutory framework, the DOC frequently must wait for the Wyoming Board of Parole to determine whether an inmate is ineligible, and it's resulting in inconsistent applications of the law, as well as, I believe, unnecessary delay. Individuals by statute may apply for an adult community correction center when they're 2 years from their parole eligibility. We've had, since we went before this committee, I believe it was July 24, we've had 24 escapes. 17 have been criminally charged. I believe 11 will have gone through the process. And Deputy Director Lamb may be able to help me out when I'm done speaking here with that. It provides a number of obstacles. We're waiting for the court to go through. The person, it takes, on average, they're gone 42 days and until their return. And many a times, the parole board's addressing every case. Many a times, the sentence has no longer the dominant sentence. So the person's expired. We never address their inability. The amendment that we're proposing would create uniformity and certainty on the administration of the statute. Regardless of who serves as director of the board or the director of the Wyoming Department of Corrections, the statute would clearly mandate the identified conduct results in parole and ineligibility. And I believe that's always been the intent. It's since 1947 the statute came about. The proposed language therefore advances consistency, accountability, institutional safety. It's my belief that when an individual escapes while they're currently under a sentence of the court and serving confinement, that individual is not ready to return to our community. I also consider this individual a safety risk. The Department of Corrections does not question the parole board's decisions. In fact, we not only respect the members, Director White and Deputy Director Lamb sitting next to me, we strongly support the separation as well as the checks and balances with the parole board. If our requests become law, it still remains the parole board's decision to determine when an inmate's to be released from custody, not the Department of Corrections. Amendments to the statute would quantify accountability. This request has nothing to do with the requirement also of the prosecutor's office. No prosecutor is required by law, and I certainly understand why a county prosecutor may not want to take a jury trial, especially in some of our rural counties. Nowhere in 713-402 does the statute require conviction. I would also comment that parole is not a right, it's an administrative process and a privilege to return to our community. Some may reply that it's only escaping from a community correction center, but I would ask the committee to consider 718-112. It defines that an offender, parolee, or an inmate is deemed guilty of escape from official detention and shall be punished provided under 65206 as the escape charge. If without proper authorization, he or she fails to remain within the extended limits of his confinement or to return within the time prescribed to an adult community correctional facility to which he was assigned or transferred, or being a participant in a program established under the provision of this act, he leaves his place of employment or fails to neglects to return to the adult community correctional center within the time prescribed or specifically to do so. I would like to return to our intent of our request. Currently, statute 713-402, subsection B states, a prisoner is not eligible for parole on a sentence if while serving that sentence, they have made an assault with a deadly weapon upon any officer, employee, or inmate of any institution. Applet 2, escaped, attempted to escape, or assisted others to escape from an institution. The proposed language that we bring before you, it would read, has been convicted in district court or found by a final determination of Wyoming Department of Corrections administrative hearing process to have, that's the additional wording, to mean an assault or deadly weapon. This change will provide if any inmate is found guilty of the aforementioned acts through the department's disciplinary hearing process after they escaped and been returned to custody, which will also provide an appellant process or criminal conviction, they would automatically be deemed ineligible, which I believe the law clearly states now. Why does the department want to take this action? Removing consequences or having no accountability when an alleged crime is committed by an individual is currently under the oversight of the DOC and the courts greatly jeopardizes our community safety. This approach is very consistent with approximately 7 years ago in the federal system. They made, which I don't believe in mandated sentences, but that's what they did, and it greatly reduced their adult community corrections escapes. As the director of Department of Corrections, my number one goal is to reduce future victims. And I also want to add to this board, there's no fiscal note with this. While we currently have the authority to unilaterally remove good time, a legislative change regarding parole and eligibility, I believe, is necessary. I don't propose a temporary fix, but a permanent measure to serve a long-term interest. Some may ask, is this request really necessary, and does the DOC appear to be punitive? Under the proposed language of this act, inmates who demonstrate appropriate conduct would still have the ability to receive earned time. Under the current statute and board rules, I can conduct a hearing now and flatten inmates for this behavior, but those individuals will spend their maximum sentence. So it is not punitive. With this change, it would still provide, they would become parole ineligible, but they would still have the ability, if they have appropriate conduct after return to get earned time. The only alternative I have right now is if we flatten the inmates, and then they are going to do their maximum sentence. And the last thing that I would do is it's two parts. 713-402 is one, if you escape, and number two, if you conduct as an assault with a deadly weapon. I would like to address the remaining portion of 713-402 is with regards to section B, assault with a deadly weapon section of the act. As I will defer to the Board of Parole, Deputy Lamb, who's to my right, it's responsible for implementing current practices and determined. The DOC has administratively attempted to remain consistent with the Board of Parole on how we address this under Title VI. The law is clear where it says violent assault with a weapon. Inmates have learned this, and sometimes we don't have without the ability to, as the language that Deputy Lamb will speak of. I think it's about serious injury. You could have someone violently assault another person at the penitentiary utilizing their hands and beat them to where they have to be life flighted, but it doesn't meet the intent of this act to make them parole ineligible. Mr. Chairman, I'll stand for questions and also turn it over to Deputy Lamb with the Board of Parole.
So Director Shannon, do you have something with the proposed changes on it for
Yes.
us? Because I don't have anything in the materials.
Oh, I submitted it with the interim topic, but yes, I do. I believe I have it with me.
So let's talk about those changes. So you're asking for changes to both BI and B2.
That's correct.
And the change to BI is it sounds like twofold. You want to expand somehow the definition of institution to include adult correctional facilities in this one as well, or is that just in B2?
No, the definition of adult corrections is already in a different statute, so that's defined. What I'm adding, and I'll present this to you at
Okay.
this time, Mr. Chairman, it's, I want to add being convicted in a district court or found by a final determination of Wyoming Department of Corrections administrative hearing of having. May I come up?
Please. Thank you. Is this your only copy?
Yes.
Let me give this to Brian, and you guys can maybe circulate this for us real quick.
Mr. Chairman, I apologize. I
So
thought I sent it.
Maybe I'm just a little confused by what the topic is itself. So the definition of institution includes an adult correctional facility already?
Yes, and the definition is already included in 718.112. That's
Okay.
clearly defined. Well, Mr. Chairman, what we're asking, the 402 states you're parole ineligible if you do these things. But the system doesn't really work that way. So what I'm asking is let's tighten it up that if you do escape, regardless if a prosecutor charges you or not, you will still meet the criteria of the act, meaning you're ineligible for parole.
I guess I'm struggling with the application then, the issue with the application of the statute, because the statute seems clear to me. A prisoner is not eligible for parole if he has escaped from any institution. So how is that not clear?
Mr. Chair,
Yes.
if I can take part in this, committee members, I also want to mention that we also have Director White and our chairperson Kathy right here as well. I think what this statute is lacking is it doesn't define exactly what process or what evidence is used to make this determination. The Board of Parole, towards the end of 2022, did develop some policy and has been using policy on these types of hearings since 2023. And, you know, what we do in our policy is if there is a criminal conviction, there's a non-rebuttable determination of ineligibility. So it's as simple as notifying that inmate that they are not eligible. And then that part is done. If there is not a criminal conviction, what the Board of Parole has done is has made it a rebuttable determination. And so we advise them that they're no longer eligible, then they can petition to have that eligibility reviewed, which is done at an evidentiary hearing in front of a 3-panel member of the board. And I believe what Director Shannon is getting to is it's kind of a duplicity of function. There has already been a hearing that has taken place through the Department of Corrections disciplinary procedures. They've been advised of the allegations of the charge, so to speak. They've had their time to defend themselves in a hearing, and they have an opportunity to appeal that determination. And so I think what this statutory addition does is streamline the process. And it effectively shortens the amount of time, because the process through the Board of Parole can take some time, particularly if we're waiting for a criminal conviction before we have that hearing. And so this language, like I said, streamlines the process, allows a shorter period of time for that review to happen.
Okay. Co-Chairman Washington.
Thank you, Mr. Chairman. Appreciate you being here, both of you today. So I come from a community with one of these alternative centers, and seems like we see in the news media frequent reports about inmates don't return from work release or school release programs or whatever. And so I think it is a significant number of people, as your statistics indicated. And it certainly affects my community when we have an offender who's supposed to be under supervision, who, for whatever reason, doesn't bother to return to the facility. So as a matter of public policy, it seems that this could be fixed simply by a rule change by the Board of Parole, that you could also determine that it was a non-rebuttable upon an administrative finding of escape, could you not?
Mr. Chair, Co-Chair Washit, that is a potential. I don't want to speak for Director Shannon, but I think his concern was if that happens, that's something that can change from different board, as different board members come on and off, as different directors come on and off with both Department of Corrections and with the Board of Parole. So having it in statute provides, it solidifies it to where that determination can't just be made by the change of membership of the board or by the directors.
Any other questions, committee? Now that I have the materials, I do have a question for Representative Webb. As this is your House Bill 170, so give us a little history of what happened to this bill in the session.
Thank you, Mr. Chairman. It was not heard for introduction.
Oh, well, that
was simple.
I guess that's very simple.
In the North Gallery.
In the North,
Or the North, in the North Chamber.
Mr. Chair.
Yes.
I do have another recommendation.
Go ahead, please.
The board would also recommend, in addition to these amendments, that we also amend 713-402BI, which is the maiden assault with a deadly weapon upon any officer, employee, or inmate in an institution. Title VII does not define assault with a deadly weapon. There is also there may be an indirect correlation with Title VI as far as the aggravated assault and battery statute. But again, this does not refer to that. So there is some ambiguity. As Director Shannon mentioned, most of these assaults that we see with the institutions, there's not necessarily a quote unquote deadly weapon used, but there are some serious physical assaults that end up in serious bodily injury. And the board would recommend changing the wording in BI to say made an aggravated assault and battery as defined in Wyoming statute 62502 upon any officer, employee, or inmate of any institution. That way it refers directly to that aggravated assault and battery statute and the definitions within Title VI, and provides some clarity for DLC to make those eligibility determinations.
What's that aggravated assault statute again?
It is 62502. And I do have the proposed wording that we can hand out for all of you if you'd like to take a look.
Yeah, that'd be great, actually. If you want to hand that to our staff. Senator Kolb.
Yeah, thank you, Mr. Chairman. So to be clear, this is just going to streamline the process and make these things happen more quickly, or has there been instances where it couldn't happen, or because of, I don't know, but it sounds like the process just needs to be more quickly gone through to get to the same endpoint. Thank you, Mr. Chairman.
Mr. Chairman, Senator Kolb.
Director Shannon, go ahead.
Mr. Chairman, Senator Kolb, yes, it would streamline the process. Some of these processes take more than 2 years to wait, and the intent of the law does not get addressed. So this would streamline it. If a person escapes, they become parole ineligible.
Senator Cole?
Yeah, thank you, Mr. Chairman. Then has someone been paroled because of this interim time period that happened? I mean, has there been instances that have that happened, or is it just going, I mean, I'd like to know, I guess, has there been issues beyond, I guess, making this move faster? Thank you, Mr. Chairman.
Mr. Chairman, Senator Colvin, I'll also turn it over to Deputy Lamb. Of course, the sentences they're currently on that they should become parole ineligible will expire before it can become addressed, but I'll turn it over to Mr. Lamb.
Thank you, Mr. Chair, Senator Cole. There are circumstances where in waiting to make that determination, the sentence that they escaped on does discharge. So it then becomes a moot point at that time because by the statute, it says they're not eligible while on a sentence, they commit that escape. So if that sentence discharges, they are then eligible on the escape offense. Through our process, it takes a longer time to get to that determination. Most of the time, they've already gone through the disciplinary process and received their escape disciplinary. And so we do have times where they would have been found ineligible, but that sentence discharged. So they're eligible on the new offense.
On your change to I with the aggravated assault language, I would assume if it's a pretty serious assault, they're going to be prosecuted. But if that's not the case, my question is about the final determination of the Wyoming Department of Corrections hearing process. What would that look like for an aggravated assault when you're, because I know what it would look like in a criminal trial where the prosecutor has to prove beyond a reasonable doubt that the elements of 6-2-502 are met. But how would that look in your hearing process?
Mr. Chair, I can tell you what it looks like right now when the Board of Parole sees those offenses, which is marked as a personal offense with the DOC disciplinary. We actually ask the Department of Corrections staff, what type of injury was it, and does this meet the criteria before we proceed with that eligibility determination. I'll let Director Shannon speak for what the internal process would be should these changes be made, but I assume it would be similar. And basically what we're looking for is the seriousness of the injury, 9 times out of 10.
Yeah, well, my concern is I understand the seriousness of the injury, and we could, if that was the crux of what we wanted to get at, we could adjust the statute to say causes serious bodily injury. But by bringing in 6-2-502, you bring in you bring in the attempt to commit the act, not just the actual serious bodily injury occurring, but you could have a situation where someone attempted to cause serious bodily injury. And that might be a little broader than what you're trying to do, or maybe that is what you're trying to do.
I think, and I'll let Director Shannon speak to this as well, but I think as long as that, if it referred to serious bodily injury, that would suffice. If the legislature felt uncomfortable referring specific to 6-2-502, at least referring to the serious bodily injury would encompass what we need.
Okay. Director Shannon?
Mr. Chairman, that is correct. The issue we're trying to address is serious bodily injury without a weapon.
Perfect.
So it would address it.
Okay. Co-Chairman Washington, go ahead.
I think Mr. Fuller has a comment.
Mr. Fuller? Representative Bratton? Sorry, I forget to look at the screen.
Thank you, Mr. Chairman. My question, I just would like that the language change to be sent to me or somebody could just also quick snap a picture of that and text it to me. I would appreciate that. Thank you.
So Mr. Chairman, Representative Bratton, I did send to the committee the first part of that change that was 2026 House Bill 170, and we'll work on getting the material that the Board of Parole provided, get that in electronic form and sent out shortly.
Thank you.
All right. Co-Chairman Washington?
Thank you, Mr. Chairman. So my question, Deputy Director Lamb, is if it's the will of this body to start moving forward with this legislation, might it be feasible for the Board of Parole to administratively through your rules change this language now? I don't know how long it would take to change your rules, but if you could change your rules while we proceed with statutory changes, I think we get the best of both worlds. We get a fix more quickly, because the soonest this could go into law for us would be what, July 1, 27? So that's my question for you is could you by rule change these things more expeditiously than statutory changes?
Chairman,
Yes.
Co-Chairman Washit. Yes, that is a potential. I can't speak for the board. They'd vote on that matter, obviously, but there is the potential for that to occur.
Representative Lean?
Thank you, Mr. Chairman. Director Shannon, I'm just curious, when we're talking about changing the definition of how an officer is attacked, how often is that occurring within our facilities?
Director Shannon?
Mr. Chairman, Representative Lean, I can report last year, and as well as the year before, we had no serious attacks on officers, but we've had assaults on inmates.
Any other questions, committee? All right. Appreciate you both. Ms. White, were you going to testify, Director White, or did your deputy cover everything? Oh, I'm sorry. I'm not going to make you talk then. Any other agencies wishing to testify? But general public comment? I'm sure everyone showed up for this one. No?
Hello?
Online?
Yes. Hello?
Just a moment. We're trying to figure out who do we have online?
Oh.
Because I don't have, I have Miss
Yes.
Hoffmeister.
Can you hear me? Can you hear me?
Miss Hoffmeister,
Yeah. Is my video not showing?
your video is not showing.
Okay, let's see.
You're just an ominous voice in our
I
committee.
do not. Oh my goodness, I apologize. Let me see how to. I'm not sure. Okay, here's a video. Let me see. Is it still not showing?
No, and that's okay. If you can't
Okay.
you can just give us your
Well,
testimony. It'd be great.
Okay. I apologize for it not showing. I had talked to you guys previously about, I had testified about absconding.
Hey, Miss
last
Hoffmeister, if
year.
you could just
Yes.
begin by introducing yourself, and if
I'm
you,
sorry.
yeah,
My name
go
is
ahead.
Valerie Hoffmeister. I'm a community member in Gillette, Wyoming. I am here representing my family and the rest of our community, actually. This whole escaping from community placement, absconding, whatever you want to call it, is very close to our family. My daughter married a man that she had to marry to live. She was able to get away from him. We found out later he had also abused my son. Neither one of them were willing to prosecute him for years out of fear of being harmed. And they have good reason for it, for all the women before him, before them, and his career criminal. My son finally decided to prosecute to try to save future victims as he would continue to return to our town. He was a transient. He would bounce from one state to another. He got jobs using 1090 forms so he could not be tracked. He finally, my daughter and son finally testified. They didn't have to testify. We did a plea. He got 2 charges. One he's serving prison time for. Second one was set aside and he was given probation for. We've been to every parole hearing. He refuses not to do classes to help himself to rehabilitate. We wrote letters against him getting community placement, very in-depth letters, and he was still accepted in Cheyenne. In Cheyenne, he was given, in my opinion, some freedoms he shouldn't have had. But we received an email basically in the middle of the night that he had not returned back. He was at large for 3, almost 4 weeks. He was reported to be in our town, Gillette, where he has no family members, no friends. This criminal is a psychopath, although his criminal record does not show it because people are afraid to report. He was here. It was confirmed by police as we took his mugshot to them. My husband and son went around notifying bars. Apparently he was on some dating app and somebody screenshot it. Everybody that knows my daughter knows the seriousness of what he can do. Sent it to her. Mr. Shannon, thankfully, he is a great director. I can't sing his praises enough. Thank you, Mr. Shannon. We were able to find phone number he was using while he was incarcerated, and U.S. Marshals went after him. We thought he was going to be criminally charged so he could no longer get parole. And in my opinion, he should not be able to go to community placement or honor farms where you're given less supervision than in prison. I understand not all escapees are this circumstance, but he is very dangerous to his victims. He's very retaliatory. I fear the day he gets out. We've taken concealed carry classes. We've taken whatever classes, because he's very much a psychopath where he minds the rules, looks nice, whatever, and then when your back is turned, and as far as I'm aware, he has pretty good record and was sent and everything going great, and then all of a sudden he's just gone. And that's how he works. That's how he operates. And I understand he might be the minority in this, but my family should not have to look over our shoulders when he's supposed to be incarcerated. We shouldn't have to watch emails that he's going up for parole hearing when he shouldn't. He should have been criminally charged. Prosecuting attorneys in Cheyenne say that it was the turnover during an election. They were over their heads. He was already captured. Therefore, they dropped the charges. I am trying to get them to recharge him. It is my feeling. We live in Wyoming. There's some things that, yeah, you're given second chances for, but other things, I do not feel that is the case. I do not feel you get a second chance when you've burnt your first one and you are on aggravated assault charges. And that's my opinion and that's my testimony. I support this. I would even add that they shouldn't be given a chance at community placement again. I don't know if that can happen, but I will push this. I will be there. I will do the work. I'll do whatever needs to be done. This won't protect my family this time, but it will protect another family, and I'll continue to work to try to get him charged to protect my family. Any questions?
Committee, any questions? Ms. Hoffmeister, we appreciate your testimony. We're deeply sorry that you and your family had to go through what you did go through, but we appreciate you being an advocate for the issues.
Thank you. I will advocate for, I'm the mom and I'm supposed to protect my family, and I will go to the ends of the earth to do that.
Absolutely. All right.
Thank you.
Yes.
Thank you all for your time.
All right. I believe that is the end of our public comment. So we'll close public comment. Committee directives on this issue. Representative Webb, you have a motion you want to make?
I do have a motion I'd like to make. I think we need to look at not only the proposed change that was originally in House Bill 170, but the proposed changes that Director Shannon has proposed.
Okay.
And see about moving this forward. At
Yeah,
another
let's,
meeting.
why don't we start with a motion to make the House Bill 170 a committee bill? Do you like that motion?
That'll be fine.
Okay.
Well, I'd make that motion.
All right.
Second.
And it's been seconded. And then if we want to incorporate the other change, we can make an amendment here. I will say, I'll speak to this a little and see if you're interested in this motion as a committee, but I think the proposal, the second proposal that you have to bring in the aggravated assault and battery statute is a little much. If you look at that statute, there's a lot that we would be bringing in. When it sounds from their testimony, the concern is serious bodily injury. So I would propose that under BI, we keep the language that we have, because you don't want to necessarily get rid of the assault with a deadly weapon. You could still have that as a reason to prohibit parole. But you could amend this language so it says made an assault with a deadly weapon or causes serious bodily injury upon any officer, employee, inmate, or institution. And I think that gets to the heart of what they're trying to address.
So moved.
Okay, it has been moved and seconded. I kind of already discussed it, but any other discussion on that? All those in favor of that motion signify by saying aye.
Aye.
Any opposed? All right, that has been adopted. What about back on the main motion? Any discussion on that? Yes, Co-Chairman Washit.
I don't think I'll bring it today, but I'd like LSO maybe to contemplate eligibility for placement at an alternative center, whether or not we might be able to add to this idea that not only would they be ineligible for parole, but they might also be ineligible for placement. I don't think it fits statutorily in this one right here, but we might want to look at an additional bill draft maybe at our next meeting.
All right, any other discussion on this motion? All those in favor signify by saying aye.
Aye.
Any opposed? So we've got that bill draft, and then Brian, we've got the second directive from Co-Chairman Washit. All right. Any others, committee? If not, we'll just keep rolling right along. We're doing good. Told you we're going to make up some time. Our next topic is a report from the Wyoming Office of Homeland Security, an update. We have Director Bud. Welcome. So nice seeing on my paper that it says Wyoming Office of Homeland Security.
Mr. Chairman, for a short amount of time. Yes.
We're almost there.
We're almost there. Almost afternoon. I'm Lynn Budd. I'm the director of the Wyoming Office of Homeland Security, which will be changing to the Wyoming Department of Homeland Security on July 1st. I have my wingman with me, George Niken, our deputy director. And I will be try to be expedient. I may not be entertaining, but I hope to be thought-provoking. So there we go. Agency transition is what I'm going to address first. It is going very well. It is a lot of moving parts, but is not difficult. So we're working in conjunction with the state budget department, state auditor's office, the state treasurer's office, ETS, and ANI to make sure we get all of the movements covered in a efficient manner. We are going to be agency 95.
So we're working on moving all of the finances from agency 001 to agency 95, hopefully with just the use of the legislation and avoiding B11 processes to make that happen. We also, in this transition, and due to the recent shutdowns, just this is kind of the financial part of it, there's many grants that have to get moved, that we have multiple subrecipients there. And so there's lots of entries to be made, but again, not a difficult process, just a tedious process. We will be asking for an extension on some of our preparedness grants due to the lapse in the government funding DHS and FEMA, and hopefully that will help with folks that are trying to get projects done at the local level and in our office as well. We do have a whole timeline set up for this transition. It appears as though we're on track to get that done. We're asking all of our subrecipients to turn in reimbursements to us by June 15th so that we can get those processed prior to the change of the fiscal year. If not, there will be a slight delay in those reimbursements after the July 1 transition because we'll have to get everything all set up again. All of our units will be the same, so you should have continuity to be able to look at activities of the agency prior to July 1st. Any questions about that?
Committee, any questions? No.
Okay, great. Another review for you. The legislature was gracious enough to fund some equipment for the regional emergency response teams, which are hazmat teams, as well as the bomb teams. There was $4 million appropriated in support of the regional response teams. That when those teams were created, clear back prior to 2010, for sure, that all of the teams received specialized equipment, specialized trucks and things, and those are all end of life. So we have been able to, with that $4 million with regard to the RERT portion of that, provide three heavy-duty hazmat engines for regional response teams 1, 3, and 4, light rescue team for hazmat unit for region 7, 3 F-550 trucks for region 2, and 1 550 truck for region 7. We will be looking at coming back to you all with a request to continue with that process, which would cover regions 5, 6, and 8. So that will likely be a request in our supplemental budget for them to get everybody up to speed. It does take 2 to 3 years to get these units put together and brought in, and with the supply chain situation right now, that might even be longer term to make that happen. So we want to make sure that we stay within a reasonable amount of time to get those other teams outfitted. We have spent $3,856,840 to date. Because these vehicles will be owned by the state and not the local jurisdiction, we are setting aside the remainder of the funding there, $143,160, to pay for maintenance and repairs on those trucks going forward, at least for that period of time. The bomb teams, we received $1.5 million to upgrade their equipment. We've actually purchased 5 bomb robots for RERTs, for bomb teams 1, 2, and 4. Natrona County and Campbell County received a large robot as well as a throwbot. 4 bomb suits, which were expired. So that was very important to get those done, as well as a digital x-ray system for RERT1, and then also some training and equipment for our explosive detection canines, specialized glasses and ear protection for them, and kennels and other safety equipment for those canines, as well as source material for them to train the dogs on. So have spent out of the 1.5, 1.489, leaving $10,000 for additional supplies as needed. We'll continue to spend on that. Any questions on that expenditure?
Representative Lean.
Thank you, Mr. Chairman. Thank you, Director Bud. Could you just repeat for me the bots and particularly the throwbot? Where did those go?
Those 2 went to the bomb team in Natrona County and the bomb team in Campbell County. what we did, just so you know the process, we brought the regional response teams and the bomb teams together and had a conversation up front with them to talk about what do you need, and what kind of equipment do you need, where is your gaps, and then also they agreed on kind of a prioritization for equipment for teams. And I apologize, I didn't address you. Apologize. So that was a team effort to talk about, you know, who needs the equipment now and who can wait a little bit. My apologies. Okay. All right. As you may have known, I'm going to give you a quick federal update. There's been a lot of movement at the federal level that you've probably heard about with DHS and FEMA. It's moving in a positive direction. This does have a tremendous amount of effect on our office, mostly with grant funding, but also for those preparedness grants. Our office is funded about 90% with federal grants. So we pay a lot of attention to what is happening at that federal level. And as we move forward, there will be a lot of things that we need to have to talk about. As you may be aware, there is a new Homeland Security Secretary, former Senator from Oklahoma, Markwayne Mullin, has already made some he's been confirmed, and he's already made some really positive changes to DHS and FEMA. Previously, our funds were held up due to the need for a procedure that was put in place by the previous secretary to sign off on any payment over $100,000. You can imagine that that's a large stack of payments. And so there was a large bottleneck put in place for funds moving towards the states for reimbursements and other things. So that has changed now to 2.5 million, and also will be handled by a deputy rather than the secretary himself. Just one small change that will make a difference. Yesterday, Cameron Hamilton, who was a previous interim FEMA administrator, was nominated as the FEMA administrator, and will have to go through the confirmation process with the Senate. There have been 3 previous temporary administrators, and that's part of the confusion as well at the federal level. When you don't have somebody who is qualified for the job, as you know, to be a permanent position, and doesn't have the authority as well. So that's a very positive move. Again, I hope that will continue to be positive, and we have confidence that it will. You may be aware that there was a FEMA Review Council appointed by the president, created through Executive Order 14180 to review the FEMA processes, and they actually at one point in time they were pushing to get rid of FEMA completely. We've moved back around to just as it is right now. There is a lot of adjustments that can be made within the FEMA procedures that will make it easier to get funding to folks on the ground that need it in a disaster, but also with the grant funding and the support from the federal level. I will let you know that that particular committee and the sentiment from the administration at this time is to certainly push additional responsibility, both in actions as well as financial responsibility to the state level. With that does come more control on the funding and how it's spent. But that will be a conversation that we will continue to have, because we will be needing to look at our staffing as far as where we're focusing our staffing with changes in this report that just came out last week, but also with regard to what they will be doing and how we will be able to handle that with the staffing that we currently have. The overall theme, which has been a theme historically, but somehow got changed over time, and that is that all disasters are locally executed, state managed, and federally supported. So again, the idea is that the responsibility for, also a big one is training, is going to be a lot of the federal training that's available right now will be gone, and we'll be responsible for doing that at the state level. So there's 10 recommendations. I'm not going to go through them all, but again, a lot as we review the report. And again, these are just recommendations to the president. So we don't know how much of those will actually happen, but it certainly is the sentiment. And there are at least 2 bills in Congress that are looking to reform FEMA as well. But there's a lot of the same as we've talked about before with the preparedness grants that support our office, we actually only have one employee that is not supported with a federal grant. That's our newest critical infrastructure position. So they did, instead of just turning the faucet off, within this report, talked about a 2 to 3 year glide path to remove those federal preparedness grants. So we will need to be looking at a plan for how we're going to be able to fund our office in the days moving forward. We have current grant funding enough to cover the budget fiscal year 27-28, but likely that will not be there for budget fiscal year 29-30. That amount at this point in time to sort of cover that funding is about $5.4 million for the biennium for us. So for continuity's sake and for the purposes of keeping our office running, we're probably going to need to look at some different ideas for keeping our staff and our office running. There is a change to the way that they are looking at disasters. We historically have not gotten a lot of disasters in Wyoming, not because we don't have things happen, but because it doesn't affect enough people, which is fine. That's a good thing, right? Except that means we don't get any federal support. That is also going to continue to become more complicated or less disasters being qualifying for funding from FEMA. We get a lot of questions, you know, FEMA needs to help, FEMA needs to help. There's so many qualifications to get a disaster. One of the things that is changing as well is the thresholds for Wyoming to qualify for a disaster. It is based on population, and it's the threshold per capita. And right now it's $1.94, which would make our minimum loss at 1.14 million to even begin to look at requesting a disaster from the federal level. The recommended fee or recommended rate in this new report is $2.99, which would make our threshold 1.75 million. It's just very hard, and that's in public infrastructure destroyed. So that's a tough one for us. We just don't have that concentration of population to get those disasters. So, you know, so a lot of the conversations that we'll be having moving forward will also be how do we support our communities after a disaster when we know that there will likely not be federal funding coming for any of that recovery. We'll just have to collectively take a look at that. There are, I want to say 38 states that have their own public assistance programs within the state, as well as individual assistance, which would be more like the housing and support to individuals after disaster. So I think it's something that we in Wyoming are going to need to look at, especially I think we've moved towards that situation a little bit with the funding for cheatgrass mitigation after wildfires. And the other part of it is that FEMA focuses really heavily on the disasters they know, which is hurricanes and other large disasters like that. They don't understand wildfire as well as, or snowmelt flooding, blizzards, those types of things. We did a disaster declaration request at one point in time, and we were denied it because it wasn't the right 24 hours that we had the record snowfall. It wasn't from 0 to 24. It was from 6 p.m. one day to 6 p.m. the next day. So hopefully some of those complexities within FEMA will get changed. But again, I think it's imperative that we start to plan for how can we support our communities after disaster. Any questions on that sort of federal level conversation?
Got Representative Lean and then Chairman Washington.
Thank you, Mr. Chairman. Thank you, Director. I'm just wondering if you could tell me, and you might have to grab it, what the budget cost for your office is that we just passed. Do you remember?
Director.
Mr. Chairman, Representative Lean, I believe the total budget, including which would be a lot of pass-through money to the local level, our grants do that, is about 24 million. So that total budget would certainly reduce the total spending authority if we didn't have the federal grants. Again, if we took all of the federal grants out and said we need to fund the office as it stands today, it's about, what did I say, 5.4 million.
Co-Chairman Washington.
Thank you, Mr. Chairman. Director Bud, One of the things that keeps me awake at night is a $40 trillion debt that we're staring down at the national level.
Mhm.
The potential for huge impacts to our state should federal dollars start being siphoned away seems to me significant. And and I'm sure you're already doing this, but some type of report to this committee anticipating down the road. What's the state's responsibility going to look like?
Mhm.
I think it could be substantial and something that we need to be planning for in addition. And secondarily, training facilities. You know, we have a law enforcement academy, we have a state fire academy. I'm wondering, has your office identified any gaps when it comes to training facilities within our state? Because I hesitate to keep sending people out of state to pick up training that a lot of people in Wyoming might need. So those are the things I just ask you to keep your eye out in the future and keep the committee informed as to what those needs might look like.
Mr. Chairman.
Director.
Mr. Co-Chair, absolutely. And as I totally agree with you, we need to be looking forward and not get in a spot where all of a sudden we're in trouble. We need to plan ahead for what responsibilities the state is going to be given with the removal of the federal support. And to your point of the national debt, the recommendations here actually will reduce the amount of money that the federal government pays out to larger disasters such as, Florida and other places that have hurricane and other large situations, large populations. So the good news is that likely they won't be paying out as much money from FEMA for those disasters, but on the other hand, that's also going to not send money to the state of Wyoming. Training is a very good example of conversations that we've been having lately. We currently have a half-time position for training, and that went to half-time due to previous budget cuts. We will likely be looking at least asking for that position to be put back to full-time to manage additional training to be brought to the state. We do have a challenge already in the state with getting enough people for classes, believe it or not. But with the removal of a lot of federal support for those entities that have done training at that level before, I think we'll see increased demand for training in the state. We do also maintain on our website right now a training site that has training within the region, so all of the states surrounding us, so that travel can be minimized and try to be, get classes filled for all of the western states who have a trouble getting people into the classes. But and again, the responsibility is probably going to be put on the state to get that training put together and developed and brought to the state. However, that gives us control over what we bring and what we're able to do as far as bring what type of training is appropriate for our state and the members of our state.
Any additional questions? All right, Director, do you have more for us?
I'm being fast.
You're doing great. No, you're doing great. Go ahead.
Yes. I wanted to give you an update on two other programs that were funded with the previous budget. One of those was support for the critical infrastructure program and the comparison of land conveyances looking for investment by foreign adversaries. We are working very diligently with our selected provider for the software program that we're going to need to work through all of those comparisons. That is Deloitte Consulting. We're finalizing our statement of work with them right now, and we'll be looking to get that put together. It is a arduous process because this is all completely new. It's not something that other states have done, and so Wyoming once again is on the cutting edge of getting some of this done. We anticipate the contract execution for July 1, kick off that project July 15th, and then the go live would be probably mid-November as we develop the program in conjunction with them. One of the bumps in the road that we've run into is the consistency of the county data coming to us. It is quite inconsistent and often missing a lot of information. We're trying to work very closely with the counties and the Clerks Association to make sure that we can try and figure out a way that isn't a huge burden on them, but that we can get the information in a way that is efficient and complete. Most of the counties work with a company called Tyler Technology. We've been working with Tyler Technology to try to help develop a system where they can just scan the documents and it will pull the information off of that. 6 counties are not using Tyler Technology. But with the bill that created this task for us, there was funding for the counties put in there and given to the Office of State Lands for distribution. It's about $10,000 a county for that. So again, just trying to work out that first grab of data is the most important thing, and we need to figure out how do we get that in an efficient manner. I hope to not have to go to a rulemaking procedure and put that burden on the counties. We want to try to work with them and figure out how do we help them get the right data to us. So that's just an example of one little bump in the road that we've run into as we develop this program. So far, to date, we've received about 300,000 submissions from the counties, trying to compare that to those critical infrastructure zones. Again, we right now are focused on mapping of what we call CWET, the lifeline sectors of the 16 critical infrastructure sectors. That would be communications, water, energy, and transportation. And of course, we're also mapping the military facilities in our state. So that's where we're focused right now. Of course, we'll be looking at the 12 other sectors as we move along, but we're starting here because those are the most important ones for the sustainability of the state. Yeah,
Director, we have a question from Senator Kolb.
Thank you, Mr. Chairman. Hello, Director Bud. Have you found anything? What have you been looking at, and have you found anything? That's my question. Thank you, Mr. Chairman.
Director.
Mr. Chairman, Senator Kolb, actually we have. We are in the process of investigations on a couple of different properties in conjunction with the Division of Criminal Investigation as laid out in the legislation. I think it's going to be a fruitful project, unfortunately, and hopefully create some more safety and security for our state.
Thank you.
Okay, I think that's it on that. One last, well, 2 topics. The rave panic button implementation that was also funded in the last legislative session. That actually has already begun at the local level. Some folks were already on the rave system for their alerting. This is for your community alerting, the notifications that you get to evacuate or something like that. And as their current contracts expire, they're moving on to the state contract. And then also some people are moving from other providers to the rave solution. Hopefully this will save a lot of money at the local level, being able to do the contract at the state level. We have previously given them some counties grant funds to pay for their local solution. So again, trying to get away from utilization of the grant funds for normal everyday sustainment, looking more to provide things for the counties that are specialized equipment and other things. That's working well. We are in the process of working with ETS, who has a program to kind of pre-contract with some technical folks. We're working with them. It's called the RAP program, and I'm sorry, I don't know what the acronym stands for, but it's basically getting extra staffing support for a technical project for a period of time. And then they've already vetted them, so we don't have to go through the complete RFP process. There's 29 different companies that they have in this kind of pool, and we'll be doing a RFP to them, which will only take 2 weeks, and trying to get a project manager on board for the state solution. If you recall, the state solution involves an app on your phone for every single state employee that has got a panic button as well as a medical alert, and that is geofenced to their building, so that if something happens in their building, if they have an intruder, they're able to just push a button and that makes that contact right away and notifies authorities that there's a problem there. Because it is geofenced, it helps law enforcement find the folks and wherever they are to make sure that they are taken care of. It also is a communication tool for general messaging or alerting, say within the Hirschler building, which has multiple state agencies in it. We're able to then alert all the folks within the Hirschler building if there's an issue in the building, maybe there's an intruder on the 3rd floor and you want them to, shelter in place or whatever. So it will take some work to get this done. Our goal is to try to get this done by the end of the year. We'll have to identify managers in every building as well as managers for every agency. We hope to, in the future be able to connect the system to the ANI employee system so that people are automatically added or removed as we go through to reduce the burden on management for that. Questions on the panic button program? Okay, just a quick little update on planning for summer events and support for local jurisdictions. There is a thing called a SEER level rating, which is at the federal level and asking for federal support. It's a special event assessment review. And depending on how that comes out, it lets us know how much federal support we can expect for that event, for the safety and security of that event. It goes from 1 to 5. 5 is basically, yep, we see you've got an event. 1, a SEER level rating 1 is, for instance, the quarterfinals and finals matches for the World Cup. So those are the very, very sort of high level events. For the first time ever, we were able to get a SEER rating of 3 for the Cheyenne Frontier Days activities. Part of that is because there will be a federal event, if you will, or a national event, which is the Day of the American West on Thursday of Frontier Days. And we expect a lot of high-level folks from the federal government to be there for that celebration. So that will give us the ability to ask for federal resources in support of that event. And mostly what we'll be asking for is drone detection and mitigation for that event, along with all of the other events that are going on over the 4th of July in many places. We actually got 4 other events across the state with a SEER rating of 4, which is a great recognition just of the fact from the federal level, hey, we have things going on in Wyoming and you need to pay attention. So we may get some additional support there. We're monitoring also any possible impacts to the state for the World Cup, the FIFA World Cup. It starts June 11th and goes through the first weekend of Frontier Days through July 19th, I believe it is. While we don't have any matches or anything planned in the state, there are matches in Seattle as well as Kansas City. So we anticipate through traffic, if you will, of teams and fans moving throughout the country. We also anticipate people will be coming from many other countries to take a look at the state of Wyoming and hopefully leave their money here with us, but just want to make sure that folks realize there certainly could be a lot of different folks in our state that maybe from countries that you maybe have never seen before. So working on that. Yeah, working. I think I'll just stop right there and ask if there's any additional questions.
Any additional questions, committee? All right, Director. Thank you for that report. Thank you for the speedy report. This is your opportunity, though. Is there anything that you need from us as a committee that would make your department life easier or that is at issue?
Mr. Chairman, I just would ask that you remain open for conversations in the future with regard to the transition that we're going to have to make as federal support changes and we take on more responsibilities. So we appreciate that. Thank you for your time today.
Excellent. Thank you. And do we have any public comment? There's nobody signed up online. All right, well, committee, it is that time for lunch. We will break until 1:30. We'll be back at 1:30 and then we'll take up, we've got 3 more topics after lunch. So don't eat too heavy of a lunch because you're not going to want to sleep through the second half of this meeting. I don't think you'll want to sleep through the second half of this meeting. Be back at 1:30.